seminar. I'm attorney Grace Bogart. Over the past year and a half, the pandemic has left its mark on community banks across Iowa, including how they operate and do business. Digital, tech, and old-fashioned drive-through banking is being utilized now more than ever. As we emerge from months of uncertainty, bankers have pivoted their efforts and strategies in order to compete in the new banking environment that's marked by continued uncertainty, change, and disruption. While this uncertainty presents community banks with challenges, it also provides a silver lining in the form of growth possibilities. Today, we are going to focus on the issues and opportunities that banks are experiencing moving forward in the new legal landscape. This morning, we have the following sessions. I will be kicking things off, talking about one emerging disruptive market, NFTs. At 9:30, John Landy will be presenting on what to do when federal agents are in the lobby. At 10 o'clock, Melissa Schilling and Jill Jensen-Welch will be talking about employee departures, non-competes, and restrictive covenants. At 10:45, David Gonzalez will be presenting on change in bank control, avoiding regulatory rapids. At 11:15, David Wetch will be presenting a compliance overview on powers of attorney. We'll then be taking 60 minutes for lunch. At 12:45, we'll resume with Brad Cruz. He'll be presenting on revisions to the Iowa Business Corporation Act and the impact on bank holding companies. At 1:15, Jeff Baxter and Ben Bruner will be presenting on loans, documentation, modifications, workouts, and non-judicial alternatives. At 1:45, attorney Rachel Soderstrom will be presenting our case law update. We'll be taking a 15-minute break and then resuming at 2:15 with Amy Plummer and David Reff, who will be presenting on bank mergers and acquisitions, specifically data processing agreement considerations and taxation issues. And then finally at 2:45, last but not least, the head of the banking law group, Howard Hagan, will be presenting our keynote speech on Iowa banking, the times are changing. I'd like to announce a couple of housekeeping items. We'll be starting each session as close to the designated times, and if there's any time left over, we'll have a short break between presentations. If you have any questions, you can find each presenter's email at the end of their presentations, or you can email questions to marketing@dickinsonlaw.com. Handout materials from today can be found at dickinsonlaw.com/newlegallandscape. This link is also in the reminder email you received this morning. Today's virtual seminar will be recorded and will be available here at the same YouTube link you are viewing today and on our website, dickinsonlaw.com. So without further ado, let's get started. Crypto has been a hot topic in 2021. Banks are asking regulatory questions on whether and to what extent they can participate in the crypto landscape. One subsection of the crypto space that has really taken hold this year are NFTs, non-fungible tokens. And although banks may not necessarily end up creating NFTs or buying and selling them, there's a lot of cash flooding into the space. And so to that extent, banks should be on notice of what's happening. And as I'll talk about later, there are projects kind of popping up where NFTs have been used as collateral to secure bank loans. But we can talk about that in a little more detail later on. So when I say a substantial amount of cash, this is what I'm talking about. This NFT that represents this tweet, drafted by Jack Dorsey, the co-founder and CEO of Twitter. He tweeted, "Just setting up my Twitter." That NFT sold for $2.9 million, actually above that. And this deal is not an exception. So if you're asking yourself, how does someone buy a tweet? Like what does that entail? You're asking the right questions, and hopefully by the end of this presentation, I can provide some answers. So what exactly is an NFT? Let's break it down. Non-fungible means it represents something that's unique, like real estate, artwork, or a diamond. There are no two that are alike, and they can't be traded one for one like cash can. So if you look at this chart, something physical and fungible would obviously be cash. Physical and non-fungible would be paintings, just like I said, real estate, diamonds. They are physical. They exist in the real world and the current reality, but they're non-fungible, meaning they're unique and they can't be traded one for one. Something that's digital and fungible would be a digital coin like Bitcoin or any other cryptocurrency that's traded similarly. And then digital and non-fungible would be where the NFT lies. So it's digital, meaning it is represented as a token, just like Bitcoin is and other cryptocurrencies. It lives on the blockchain, but it's non-fungible, so it represents something absolutely unique. So with that in mind, let's dig a little bit deeper. So at its essence, what exactly is an NFT? What does it look like and what is it comprised of? Basically, and I'm going to use digital art as a prime example of something that an NFT represents ownership of. It's the easiest example, and right now in the beginning stages of NFTs, that's how it's primarily used. But we'll talk a little bit more about the possibilities and the other avenues that can be explored with NFTs. But let's take a piece of digital art, an original, and we take the data from that original and we place it into a hashing function. Like if you're familiar with blockchain at all, that's exactly what we're doing. We are taking that data and we are putting it through a hashing function and turning it into a completely unique thumbprint that represents that original piece of art. Now, if that art is altered in any way, the data that goes into the hashing function will be different. So the thumbprint after that hash will be completely different than the original NFT. So in a way, by purchasing an NFT, someone is purchasing an immutable, permanent proof of ownership of this original piece of art. And if that piece of art is changed in any way, it'll be absolutely apparent because the NFT will not be the same. The hash will be completely different and it'll break the chain on the blockchain. So it's a permanent and an immutable proof of ownership of a piece of digital art. But what exactly is someone purchasing? Like when I first heard of NFTs as an intellectual property attorney, my first thought was, are they purchasing the copyright to the original piece of digital art? Because these high-end, large numbers that these NFTs are selling for, I couldn't really wrap my mind around where that value is coming from. So my brain immediately went to, they must be buying the underlying rights associated with this piece of digital art. And that can be true, but it's not always true. It really depends on the contract terms that's coded into the NFT itself, because really an NFT, all it is code. And it's a smart contract. So if you're familiar with smart contracts on the blockchain at all, that is exactly what an NFT is. So depending on the specific NFT that someone's purchasing, they could be purchasing an underlying copyright. They could be purchasing the right to distribute this digital art. They could be purchasing a variety of different things, but they also could be purchasing just the ownership proof and nothing else attached. So reading the contract terms is absolutely important when it comes to NFTs, to knowing how it's valued and what is being purchased specifically. So here are a few examples of some pieces of digital art that have been sold as NFTs. This middle video clip from Beeple, if you've heard of Beeple, they are kind of the leading NFT artists right now in this space. This video clip sold for $6.6 million. And the other two are of no exception, right? We have these high dollar amounts. And again, what exactly was sold, I have no idea unless I looked into the NFT and the contract terms within it. But it's just so interesting. So what is the hype and where does that value come from, especially if the contract terms don't transfer underlying copyrights or other rights associated? I think that one aspect of the value comes from participating in a space as it's happening and as it's starting, and being one of the first people to engage with an NFT has some value. The proof of ownership of an underlying piece of digital art also has value. It's a way of not ever being erased. And I'm going to plug Dickinson Law's podcast, Beyond Juris, right now. One of our recent episodes, I interviewed Chris Draper, and we talked about NFTs. Chris Draper owns a blockchain technology company called Troc. And what he does is similar to NFTs, really. He takes contracts, legal contracts, runs it through his hash function, and creates a thumbprint representing that original contract. And so it's a way for companies to be able to prove the digital original of a legal agreement, which in this new space where contracts are being signed digitally and held digitally, and we may not even ever see a physical paper contract with pen and ink, it's a really valuable resource. So I interviewed Chris Draper, and we talked about NFTs. And he had really interesting commentary on our culture right now and the fact that there's so much data out there. And so to own an NFT is to permanently associate oneself with a really cool piece of pop culture, and to associate oneself in that way that can never be changed and will always be apparent. There's a lot of value associated with that, both monetarily and intrinsically. So that, I think, explains some of the hype. Now, not all of it. I think that there is some inflation, some inflated value associated with NFTs, but not always. So beyond digital art, what can NFTs be used for? There are experiential NFTs. So for concerts and concert tickets, there's one example. The Kings of Leon band has created an NFT that represents the right to purchase a front row seat at all of their concerts going forward for the rest of their existence. I believe that NFT sold for about $140,000. So really what's interesting is if your favorite band created an NFT, wouldn't it be very valuable to you to be associated forever, like in the history books, with that band, and you owned maybe part of their song or part of their music video, or you had some ownership in the right to the front row seat in all of their concerts. So gaming, beyond digital art, you can use NFTs for gaming. There are a lot of video games where there are literally virtual realities, and people have avatars and they shop and they buy and sell real estate. So real estate in virtual worlds is being sold via NFT, and for high dollar amounts too. Time can be put into an NFT because it is a non-fungible asset. So if I, as an attorney, wanted to create an NFT representing an hour of my time, people can purchase that time on the open market. How cool is that? And especially for artists and independent contractors, this can be a really great way to open up their business to the open market and sell their time via NFT. So let's talk about the benefits and the drawbacks of NFTs. And I'll start with the drawbacks so we can end on a positive note. NFTs, like I've said, can be an uncertain investment because a lot of the value attributed to an NFT is oftentimes intrinsic. It's what does it mean to that specific person. Here's another example, and I have to credit Chris Draper for this example. There was a car at the Indy 500, and it's a brand new car. So you have all these car lovers, these Indy 500 goers, and the first time that car made a gear shift, they recorded the audio and created an NFT representing that audio of the gear shift occurring and sold it as an NFT. So there are people out there who could have ownership of that very first gear shift of this car that they love. So there are just so many possibilities. But again, uncertain investment because that value comes from an intrinsic source. Also, there's some inflation. It's a brand new market. It's an emerging market. So there is some inflated value there as well. An environmental cost. The environmental cost of running the blockchain is immense. I've written an article on this topic, which was published this spring, in the Environmental Law Reporter. And I can share that too if you have any interest in this topic. Feel free to email me. I'll send it right over to you. But the carbon required to run these computers, these nodes, and operating the blockchain is extreme. And there are ways that can be reduced, and experts are working through that problem now. But it is a drawback of NFTs, and it's one that we should not ignore. There are more environmentally friendly ways to buy and sell interest in digital art and the like. So, as I also said, they are often legally misunderstood. What exactly someone is purchasing, especially if they're kind of an amateur in the space and they just want to participate. It can be confusing, and they can be unclear in what exactly they're purchasing as far as the contract terms that are being assigned to them. So that is another drawback. So benefits. Why are NFTs good? Well, they're undeniably unique. As I said, non-fungible, they are unique, and they're on the blockchain, so they cannot be changed. They're permanently recorded, and that carries a lot of value. Also, there's just a hype and excitement around it, and although it's hard to quantify that, it does have a benefit. So where are we headed next? So as I've talked about, most of what NFTs represent are digital assets. And as far as representing something in the physical world, we're not as advanced when it comes to NFTs. So I'm trying to think, experiences, that represent something in the real world, but it's not a physical object. It's an experience. It's still kind of intangible. And representing physical items in NFTs has its troubles, and I think experts are working through that. So I think in the future, we will be seeing NFTs representing physical items, and we'll have people digitizing all of their physical assets and buying and selling via NFT that way. Where else are we headed? At the beginning of the presentation, I mentioned that NFTs have been and will be used to collateralize loans. Right now, there are DeFi applications, and DeFi meaning decentralized finance, so finance on the blockchain, that let people borrow money by using digital coins as collateral. So for example, if you collateralize 10 Ethereum coins, you can borrow 5,000 stable coins, which I'll talk about in 1 second. It's a digital coin linked literally to the US dollar, so it is stable. This guarantees that the lender gets paid back. And if the borrower doesn't pay back the stable coin, the lender can exercise its rights to the collateral, the NFT. One thing projects are beginning to explore using NFTs as collateral instead of, in the last example, Ethereum coins, which is another digital asset. It's a fungible asset. So imagine if you bought a rare NFT in this space right now, and it just keeps gaining value as time goes on. By putting this up for collateral, you can access a loan with the same sort of rule set. If you don't pay back the stable coin that you've borrowed, your NFT will be sent to the bank or the lender as collateral. And this could eventually work with anything that you tokenize as an NFT. And so I wanted to come back to stablecoin because the OCC and other regulatory agencies are actively providing guidance on how banks can use stablecoins in their operations. And as far as using it as a digital asset, lending stablecoins as a digital asset, they haven't quite gotten there yet, but there is OCC guidance on using stablecoins to actually transfer funds. So you use the coin itself as kind of a mechanism by which funds are transferred and quickly. So banks are already using stablecoins, and this is just another way of branching off into using stablecoins as a method of providing loans, and you can collateralize them by using NFTs. If there are any questions, please feel free to contact me at gbogart@dickinsonlaw.com or give me a call on my direct line right on the screen. I think that we have about 5 minutes before the next presentation. So go ahead and take a quick 5-minute break, and we'll be back with John Landy, who will be presenting on what to do when the federal agents come into your lobby. So stay tuned for that.
My name's John Landy. I'm an attorney at the Dickinson Law Firm, and I'm here today to talk to you about what to do if you're at the bank and all of a sudden you find out there are federal agents standing in the lobby of your institution. It's a jarring experience for any organization, and so it's important that you have an understanding of what you need to do in that circumstance and what that may mean for your institution in the coming weeks and months after that occurs. So to get started today, what we're going to talk about are basically three different types of requests that your institution may receive. The first has to do with subpoenas that you might see in the ordinary course. These could be civil subpoenas that you get as part of a lawsuit. They could be as a result of some regulatory enforcement proceeding, or, as we'll see as well, they could be related to a criminal investigation. So in addition to talking about subpoenas, we're also going to talk about different types of criminal requests for information, formal agency or governmental requests for information, as well as search warrants, and how your institution needs to respond when it receives those types of requests. Lastly, we're going to cover what to do when it becomes clear that the institution or individuals within the institution are the subject of a criminal investigation. And there's a lot of different considerations that an institution needs to keep in mind when it learns of the presence of a criminal investigation, which it may learn about because, as the title suggests, federal agents are standing in the lobby of your institution. So before we really dig into the ways that your institution and organization should respond, it's important to understand a little bit about the legal and regulatory framework that kind of underlies and forms the foundation of how your institution responds to different types of requests for information that it may receive. The first source of law that we're going to talk about is the Gramm-Leach-Bliley Act, which almost everybody here who's watching this presentation is familiar with, even if they don't know it exactly by name. Gramm-Leach-Bliley is famous for requiring that customer information be maintained confidentially at the institution. That's a core obligation of your institution, and it's something that is ingrained in every bank employee and officer's thinking about how they treat information within the institution. There are, however, exceptions to those confidentiality requirements, and those exceptions relate to some of the methods for the requests of information that we've already talked about, specifically subpoenas and criminal search warrants. As you can see here, the institution's obligation under Gramm-Leach-Bliley contains exceptions where an institution may disclose information to a third party in a couple of different circumstances. The first is to law enforcement authorities, as long as they have issued a proper request under the Federal Rules of Criminal Procedure and consistent with the Right to Financial Privacy Act. The second is if the organization has received a properly authorized civil or administrative subpoena. Now, the key to that exception to the confidentiality obligation is that it has to come from an appropriate jurisdiction or court, which we'll talk about in a little bit. Before we get to the exception related to jurisdiction, or before we talk about the jurisdiction for subpoenas, though, we need to understand a little bit about the Right to Financial Privacy Act. Similar to Gramm-Leach-Bliley, the Right to Financial Privacy Act protects the information that belongs to an institution's customers and depositors. The Right to Financial Privacy Act prohibits the sharing of information with government entities, whether that's the IRS, whether that is a other type of administrative investigation or investigatory agency, or a law enforcement. Now, there are exceptions to that prohibition on the sharing of information with government entities. And the exceptions are listed out on the slide that you can see on the screen. The first exception, of course, is if the customer authorizes disclosure to a governmental entity, which in some circumstances they may, particularly if there's an IRS audit or something like that. However, in many cases, the bank will receive a request for information that is not known by the customer. In other words, there's an investigation occurring in the background that a customer is not aware of. And in those circumstances, the institution needs to be careful to follow the slides or follow the exceptions that are also identified under the Right to Financial Privacy Act. Those include getting a properly authorized search warrant from the governmental entity. It may require a properly authorized subpoena from the administrative entity that you're dealing with, or in certain circumstances, a written request from the governmental entity that is actually requesting that information. Now, these exceptions to the Right to Financial Privacy Act are much more detailed than what the slide on the screen indicates. All I'm explaining now is that there are certain circumstances in which you as an institution, when you receive a proper written request from one of these governmental entities, can actually disclose that information to that governmental entity. But it's important to make sure that before you do, you have actually complied with the requirements of the statute. Now, where I see this come up a lot is whether or not that particular government request is from a properly authorized court, government agency, or jurisdiction. And as financial institutions have started to expand their markets and enter into contracts with fintech companies, for example, they've started to see their customer bases expand beyond the local deposit base that they've traditionally done business with, and they start to see connections and contacts with other states outside of Iowa. And as that's happened, they've come into contact with different regulatory or law enforcement agencies that may from time to time have requests for information from the Iowa-based financial institution. And when that happens, it's important for the financial institution to determine whether or not they actually have to respond to that law enforcement subpoena or warrant that comes from a jurisdiction other than the state of Iowa. What I've seen happen a lot is an institution will have a customer or some other contact with a state, other than Iowa. Could be New York, could be California, could be Texas. And there will be an investigation into that customer in that state, either by a civil entity or by a criminal entity. And they will send a subpoena to the financial institution located in Iowa and demand that the institution turn over information to that agency located in a different state. And they will get very frustrated with any institution that comes back to them and says that they don't have to comply with that so-called foreign subpoena or request for information because the institution is not subject to jurisdiction in that state. As you saw under the Right to Financial Privacy Act and under Gramm-Leach-Bliley, both statutes require as a precondition to disclosing customer information to an agency that the request be properly authorized and that the institution actually be subject to jurisdiction in the location where the governmental entity is making that request. So in the example of a Texas law enforcement agency issuing a subpoena to a bank located in Iowa, the Iowa bank is not subject to the jurisdiction of the courts of Texas. The fact that the bank may have a customer that has resided in the state of Texas does not necessarily mean that the bank is subject to the laws of the state of Texas. And so in that circumstance, if the entity just turns over financial information of that customer to the agency or entity located in Texas, it may be subjecting itself to liability or exposure for a violation of Gramm-Leach-Bliley and the Right to Financial Privacy Act. And so in those circumstances, it's important that the institution actually conduct an evaluation to determine whether the request is in fact properly authorized by the agency that's making the request for information. And the reason I mentioned fintech relationships as being particularly problematic is that very often the financial institution is the one that has the relationship with the fintech, and then the fintech is the one that has the relationship with the customer. However, in that circumstance, we've got a layer in between the financial institution and the jurisdiction where the customer may be located. And so from a legal standpoint, it's important that the organization makes sure, the financial institution makes sure that it is in fact required to respond to that subpoena. If it's not required to respond to that subpoena, then it shouldn't be turning over that information. Now, some of you might be thinking, well, John, that doesn't make any sense, because if somebody commits a crime in Texas and the Texas authorities want information from my institution, why can't they, or how can they be prevented from actually getting that information from me? And the answer to that is that there is a mechanism for a foreign, quote unquote, foreign entity like law enforcement in the state of Texas to actually request that information of an Iowa institution. They have to come to the state of Iowa, and they have to actually have the request issued by an appropriate agency or an authority within the state of Iowa. And there's procedures that are established to do that. So it's not as though the information can't be retrieved by the foreign entity. Rather, the issue is whether they followed the proper procedure to get it. Now, you might be thinking to yourself, well, that seems like form over substance, and it may seem that way, but that's the way the law is written, and it's important that when it comes to the confidentiality of bank information and customer information, that we follow the law as it's written under Gramm-Leach-Bliley and the Right to Financial Privacy Act. It may come as a surprise to many of you that in some cases people can be lazy, and those foreign law enforcement agencies or foreign attorneys may just not want to jump through the hoops that are necessary to actually get that information. And so as we continue to think about what we do, how we respond to requests, I now want to kind of shift gears and talk a little bit about what to do in the event that those law enforcement authorities actually show up at the institution. And you find yourself in a situation where you have agents from the FBI or the offices of Inspector General of either the Federal Reserve, FDIC, or one of the other federal agencies. In that situation, in many cases, the agents will ask to see a particular individual within the institution, somebody in a position of authority, who more than likely can accept service of a document. And in many cases, that document is a subpoena potentially issued by a grand jury as part of a criminal investigation seeking information about the institution. Now, what distinguishes the situation where the federal agents have shown up in the lobby of the bank from some of the other requests that we've been talking about now is, in many cases, or in some cases at least, there's a risk or a possibility that those agents are not there about some unrelated third party that they may be investigating, but actually there to investigate the financial institution itself or individuals who are employed by the financial institution. And so whenever you have a situation where there are law enforcement authorities who are in the institution asking questions, asking to see people, it's important to gather as much information as you possibly can and try to understand the purpose of their visit. If they are there just to serve a document, it's important that you take the document, you make sure not to lose it, and that you try to understand why the document is being issued, why the subpoena is being sent to the bank specifically, why the investigators may be trying to retrieve information about the financial institution or about certain individuals within the financial institution, because that's information that will become important for attorneys later on to try to assess what the agent's inquiry is actually about. It's important that the organization obtain business cards for the agents. More than likely, the agents will provide those, along with showing proof that they are in fact authorized federal agents. And in some cases, they may start to try to ask questions of the individuals that they meet with. In those situations, unless there's an attorney present or there's a clear understanding of the purpose of the agent's inquiries about the institution, more than likely the appropriate response is going to be to politely decline until you've had an opportunity to review the material that the agents have provided and potentially talk to an attorney if the circumstances warrant it. In the event that the agents are there to serve a subpoena from a grand jury, that grand jury subpoena very likely will request documents either about customers or about business dealings at the bank. One of the things that's important to keep in mind when responding to that type of request that you may get from federal agents is the FIREA statute. Now, under FIREA, it is actually a crime to disclose an investigative subpoena that the bank has received. And so it becomes very important if the bank has received a grand jury subpoena requesting information, whether it's about customers or about people at the bank, to make sure that the information that's being sought is tightly controlled. And that the presence of the subpoena is only made known to people who actually need to know that it exists in order to do their job. Now, if the investigators are investigating a particular individual at the institution, and that individual happens to be the one who accepts service of the subpoena, then there's nothing more that can be done about that. But if it involves somebody else at the bank that nobody that was not present for the agent's service, then you'll need to consult with an attorney before you start to disclose the existence of this subpoena to any of those individuals. These matters are highly sensitive, and it becomes important to quickly respond to them and engage an attorney who can help you understand what the purpose of that subpoena is. And so as that attorney gets involved, one of the first things that you'll do is try to understand the scope of the investigation and the scope of the issues under consideration. You want to understand, is a customer under investigation? Is an individual within the institution under investigation? Is the entity itself under investigation? You want to understand if there's prior conduct that has occurred, things that have happened in the past that are now being investigated by federal law enforcement authorities, or you want to understand if it's current conduct, if there are things that are going on right now that you need to be aware of because you may need to take some mitigation measures. For example, if a customer account is being used for money laundering, you may need to take action to file a suspicious activity report immediately if it was something that you had not previously identified. If it relates to an individual within the bank, however, an employee or officer who's under investigation, if there is current issues or are current issues that it appears the investigators are looking into, you may need to do a very quick assessment as to whether or not the bank needs to take any remedial action to try to limit the harm that somebody may be causing to the financial institution. And the status of that person within the organization is very important, whether it's an employee or officer of the institution, because your response as an institution may differ dramatically as to based on whether it's a relatively lower level employee versus an officer or maybe even a director of the institution. So in a world where the institution has received a grand jury subpoena from federal agents that is seeking information related to officers or directors or employees of the bank, it becomes very important to then have a quick response so that you are certain that you are both complying with the requests of the investigators and then also doing what you can to protect the institution. One of the things that you will want to consider doing is contacting regulators to alert them to the presence of an investigation. Those conversations with regulators are confidential, and so to the extent that the investigation touches on the safety and soundness of the institution, you want to try to explain to them what your understanding of that investigation is as soon as you have an understanding of what that scope of investigation is. You're probably more than likely going to be consulting with an attorney for the institution to help the institution understand why the request for information is being made by federal authorities, and then ultimately to respond to that request for information from federal authorities. In many cases, providing the response is fairly straightforward, although depending upon the scope of the request, it may require collection of a substantial volume of material from the institution, both stored in electronic form as well as in paper form. And you'll need to make sure that you're working to keep that information organized, not just for the benefit of the investigators, but because you as an institution may need that information at some point in the future. And having it in a readily digestible form will make life much easier for the institution as potentially the investigation proceeds. If it becomes clear that individuals are under investigation by federal authorities, individuals within the bank, It'll be important for the bank to ascertain whether or not any action needs to be taken to remove those individuals from the bank pending the outcome of the investigation, or if it appears to the institution that the individuals have not done anything that the institution believes is criminal, or at least there's a dispute about whether or not what was done was criminal, those individuals may continue to work within the bank. And then the question becomes, depending upon their level within the institution, whether those individuals need to retain individual counsel, and whether the financial institution is going to be the one that actually pays for that individual counsel. Now, under Iowa law, banks, if they provide for it in their articles of incorporation, have the ability to indemnify directors and officers of the institution for certain attorney's fees that they may incur as a result of their position within the bank. And that can include reimbursing them for attorney's fees that they may incur as the result of a federal criminal investigation, or any criminal investigation for that matter. Now, in order for a financial institution to actually cover the costs for an individual officer or director of the institution, first and foremost, their articles of incorporation have to allow for it. And then they have to make sure that they've satisfied the factual prerequisites for actually obtaining indemnification for the institution, which in most cases requires a finding by the board of directors of the bank that the individuals have not engaged in conduct that is either a breach of fiduciary duty or is otherwise criminal in the judgment of the board at the time that question is presented to the board of directors. If the board concludes that the individual officers and directors can be indemnified, then it's also important that the individual officers or directors who are going to be indemnified, who are going to have their attorney's fees covered, sign agreements agreeing that they will repay the institution in the event they are found to either have breached a fiduciary duty or are convicted of a criminal offense. And as I hinted at or alluded to there, this indemnification is available both to officers who are accused of a civil breach of fiduciary duty as well as potentially a criminal violation. And so it's important, as I mentioned earlier, that the organization understand the scope of the documents being requested by the federal authorities so it can understand what it needs to be looking at to make the determinations at the board level as to whether or not the officers or directors who may be under investigation by the institution should in fact be indemnified by the institution and have their attorney's fees covered. Now, if the institution determines that the attorney's fees should be covered, then it becomes important to retain counsel for the individual that will have a good working relationship with the financial institution's counsel, and they'll be able to coordinate their efforts to make sure they're sharing as much information as they can about the scope of the investigation and about what each side is learning about what the federal investigators are looking for. Ultimately, the risk to the institution in these circumstances is of a public relations problem. In other words, if there is a public indictment of somebody who's important at the bank, or if there's some other type of action that occurs that is detrimental to the institution, that the public messaging around that incident is controlled in such a way that it doesn't result in either a run on the bank or other kind of long-term harm to the financial institution. And ultimately, if the individuals who are under investigation are exonerated or are ultimately the case is dropped, then of course, the institution doesn't need to worry about any of that PR, those types of PR risks. But the point here is that these types of situations can be rapidly evolving. It's important to have professionals who understand how to respond to them and make sure that they're doing all of the things that are necessary in order to protect the institution. And lately this has become somewhat critical or somewhat significant because we have seen an increase in the number of these types of situations occurring within the state of Iowa. And so it's important for organizations to make sure that they're doing everything that they can to be ready in the event that something like this happens and to respond to it quickly and efficiently in the event that they learn about either an investigation of a customer or of an individual at the bank. And so with that, if there are other questions or comments, you can certainly reach me directly at my email address and phone number. I'm happy to kind of talk through issues. More than likely, the first time that you'll ever encounter any of these issues is when you receive a subpoena. If the subpoena comes from the state of Iowa and is properly issued under Iowa law, there may not be much for you to do other than to respond to the subpoena. But if you receive any other type of request that comes from out of state or from a federal agency or even from a phone call from an IRS agent, then you're going to have some of the issues that we discussed today and going to need to take a close look at whether or not providing information complies with the statute and whether or not there are any other issues that you need to be concerned about addressing. So with that, thank you very much for your attention, and I look forward to having an opportunity to speak with you in person. Thank you. Next, you'll be hearing from some of our employment attorneys who will be talking to you about issues related to employee departures, as well as non-competes and other types of agreements and restrictive covenants that you may have with former employees.
My name is Melissa Schilling, and I'm a shareholder at Dickinson Law Firm and practice employment law.
And I'm Jill Jensen Welch, also a shareholder at the Dickinson Law Firm practicing in employment and labor law.
And today we're here to talk to you about employee departures, non-competes, and restrictive covenants. The reason why we thought this topic was so important and timely this year is because we have seen a huge number of transitions between financial institutions within the last 12 months. In particular, we are seeing groups of employees leave together, which is causing a huge stress on the financial institution that they are leaving. And so we wanted to talk to you about how to protect not only your confidential information, but your customer relationships through restrictive covenants here today.
I think the other thing, Melissa, that I'm seeing, and you probably are too, is that there's a lot of movement of personnel among banks. And so when you're hiring new loan officers, credit analysts, et cetera, investment people, they may be coming with a restrictive covenant from another organization. And we've been having to negotiate with these other organizations about what these employees can and can't do, or whether we should or shouldn't hire folks.
Yep.
So it's kind of on the front end and the back end.
Yeah, and that's exactly right. Some financial institutions that hire people with restrictive covenants will just completely ignore them, and you're forced into a lawsuit, which we're going to get in later today, whereas others will be more aware of them and willing to engage in negotiations with you.
Exactly. Speaking of departures, you might notice Brian O'Neill isn't with us today.
He's in a trial today. He's sorry he can't be here. Okay, so the first thing we wanted to talk about is just the different types of restrictive covenants. So there's three basic types. There's non-competes, non-solicitations, and non-disclosures. Each one protects different types of things. So a non-compete would prohibit your employee from going to a competitor financial institution within a geographical region for a restricted time period. Jill, I don't know if you want to hint on non-solicits?
Sure. Non-solicitations can be both prohibiting your employee from soliciting customers when they go to a competitor, or soliciting your employees. So there's kind of two types of non-solicits. I typically recommend both for my clients.
Yeah. And then there are non-disclosures, which is essentially a provision in an employment agreement that prohibits your employees from using your confidential information in their new employment. So confidential information could be customer lists, customer contact information, loan information. All of that could be included in a non-disclosure. And the other thing to note is that an employment agreement, a good employment agreement, would have all three of these restrictions in them. However, not all employment agreements do have all three.
Yeah, some of my employers don't want to go so far as to have a non-compete. They don't want to stop their employee from working in their industry or working in their profession, but they do want to stop them from taking their customers. So some of my employers only have the non-compete for the time when they're employed, and then after employment, the non-solicitation is the one that they really rely upon.
Mm-hmm. And some employees are under the impression that these are not enforceable in Iowa.
And some attorneys.
Yeah, some attorneys.
Under that impression too.
But they are absolutely enforceable here in Iowa. Restrictive covenants are governed by state law, and so the law varies by state. So if you do happen to have a financial institution in a different state, say Minnesota, Illinois, Nebraska, the way we would draft these would be slightly different than how we would draft them in Iowa. But for your perspective, they're absolutely enforceable. If an employee refuses to sign them, you could go ahead and move forward with termination if you wanted to.
Or not hire, yep.
Yeah.
And for those of you who do happen to have employees working in Illinois, across the river, Illinois passed a new law just earlier this month that goes into effect in January that's going to change the landscape. So if you've been thinking about getting some non-competes in place, it could be a good time to get them in place before January 1, because there is a grandfathering piece to that new law. Beyond the scope of what we can talk about today, but just kind of an FYI for those of you with Illinois side branches.
And in Iowa, you could have an employee sign a restrictive covenant at any point during their employment, at hire, a few weeks after they're employed, 5 years down the road, whenever you want to do it. Now, if you want to have them sign it once you've terminated them, you're a little too late. But you could always offer them a severance package in exchange for signing some restrictive covenants, which I've done recently and have done in the past in order to prevent the employee from going out and competing against you and soliciting your customers.
It makes it tougher to get them at that stage, and lots of times I'm unsuccessful. You know, they just want way too much money in exchange for that. So you can get it for free at any point during employment. So that's when you want to get it in Iowa.
And with all the transition, we would recommend that you seriously consider getting these restrictive covenants in place as soon as possible. Because without them, we're going to get into this, it's going to be much more difficult to go after them for essentially stealing your customers.
More and more of our clients are having these, and we're seeing more and more of our clients, new hires, having them. So I think it's really becoming kind of the standard here, at least in Iowa, in the financial institution industry.
So let's talk about having just a policy versus actually having an employment agreement with restrictive covenants in here. So oftentimes, banks or credit unions will have policies that prohibit employees from using confidential information, maybe say something about not competing or a duty of loyalty or non-solicitation, but those don't have the teeth that an employment agreement with restrictive covenants would have. And Jill, I don't know if you want to explain that.
Well, in particular, a policy only really gives you enforcement authority while the employee is employed. And once they're no longer employed with you, that policy has no impact on that employee any longer. Furthermore, most states, including Iowa, require a signed agreement, a contract, in order to bind someone to not compete or not solicit with you after their employment ends. So you're really going to need to have something in writing and not just a policy. And if I may, I have a recent incident of that where I had an employer, a financial institution, that really was philosophically opposed to restrictive covenants in most of their positions. Now, they did have them in their investment department, but not for their loan officers and other typical banking side. But they did have a confidentiality policy in their handbook. And they pulled this policy from the handbook, and it had in the footer that it was the confidential information policy. And they slapped on a paragraph about, I agree to this, that, and the other thing, and a signature line. And one of the lines said, I agree to comply with this policy. So when it became an issue and opposing counsel got involved, they said, this isn't an agreement, this is just a policy. And it's not enforceable after their employment is done. And, you know, I pointed out the places where it said agree and agreement, and the fact that it mentioned policy twice, once in just a footer, had no bearing on the four corners of the document, made it clear that it was a contractual obligation and agreement. But it just gave them another thing to argue about, and it gave me something that I had to fight with them over. So if you are going to try to have policies and pull them from your handbook and have people just sign them, you really need to draft them a little bit differently. The language is really different, and make sure we're, you know, taking policy out of it.
In terms of enforcing these types of policies, like Jill said, you can't really enforce them after they're gone. What they would be evidence of is potentially how the bank protects its confidential information. So we've filed claims or lawsuits before with claims for theft of trade secrets, conversion, intentional interference with the customer relationships, and using the policies as evidence of how we protect our information, but it still doesn't give you the teeth that a contract with explicit restrictions would have. It's much more difficult to go into court with just a policy than with an actual contract. One other thing I will add is just because you have a contract with restrictive covenants doesn't mean the employee is now a term employee or no longer an at-will employee. The contract would specifically state they are still an at-will employee, meaning either the employee or the financial institution can terminate their relationship at any point in time for any lawful reason, with or without notice. So don't think you're getting into some sort of just cause standard just because you're going to have an employment agreement now with them.
Excellent point. Excellent point.
Okay, so when is restrictive covenants appropriate? Jill, I don't know if you want to talk about, we kind of hinted at governed by state law, but more of what's enforceable in Iowa?
Sure. Iowa's a pretty employer-friendly state when it comes to these kinds of restrictive covenants. Most Iowa courts will enforce them. You're always kind of facing an uphill battle, however, because you're the big, deep pocket financial institution suing this little poor employee, regardless of how much money they might have made and how rich they might be. Courts and juries tend to kind of side with the little guy, in the David Goliath kind of situation. But still, Iowa is very good at enforcing restrictive covenants when it comes to other states. You would think Nebraska would be pretty good at it, but they're not. They have got some really employee-friendly case law out there. Illinois' law is really quite different from Iowa's law. And so if you've got employees in neighboring states, you really need to meet with us. And we do try to keep up. We do research for various clients on various states to try to keep up with what each state requires.
Yeah, and even though it is the David and Goliath situation, sometimes that can help at the initial onset when you send them a cease and desist letter.
Yeah.
They will back off because they can't afford to fight the Goliath. However, when a financial institution on the other side backs this employee and pays their legal fees, you're in for a big fight. And we will get into kind of the expenses associated with a lawsuit like that. But it does help if if the financial institution they go to is not willing to support them, they can give up easier.
Right. And that usually happens if your former employee is actually engaged in some pretty serious wrongdoing. That's usually when the new employer either fires them or is not willing to back them because in the lawsuit they may, have to part ways and take different arguments.
So let's talk about how long you can prohibit an employee from competing or soliciting your customers, and how long you can prohibit them from using your confidential information. Well, in Iowa, you can prohibit them from using your confidential information indefinitely.
As long as it's still confidential.
Yes, as long as it's not becoming public, the bank is still treating it as confidential information. You can prohibit them from disclosing it or using it indefinitely.
And that's not the case in all states. Some states limit it to a certain amount of years. I've seen 10 years, others no more than the usual other restrictions on non-competes and non-solicits, so like 2 years. So it depends on what state you're in, how long you can protect that information.
Yep. And then in Iowa, we typically recommend about a 1 to 2 year non-compete or non-solicitation. Those are typically enforceable in Iowa when it comes to employer-employee relationships. Now, when you're getting into a sale of a financial institution, the standards are a little bit higher, and you can prohibit an owner from not competing or not soliciting your people for a longer period of time.
Correct.
The other thing is, one of the things you need to consider if you're going to look into implementing these restrictive covenants is what type of employees do you want them to sign. We're not talking about tellers here. We're looking at people that actually have a relationship with customers and actually have access to confidential information. So loan officers would be a group. Jill, I don't know if there's other groups that you've seen.
Yeah, for sure. I mean, the investment people, the insurance people, if you have those kinds of pieces of your business, credit analysts sometimes too, because they're working really closely with the loan folks and analyzing the credits on the loans. I think, access to confidential information, almost every employee in the bank has access to that, even tellers, because the depository information is confidential as well. If they have knowledge of your confidential information or trade secrets, even if they don't have access to the data, access to your customers, access to other employees if you want to limit the non-solicitation on employees, and also, of course, the level of the job. How important is the job to the organization? If that employee were to leave, would customers follow them? Would employees follow them? If not, you probably don't want to have a restrictive covenant with them.
Yeah.
Do you want to talk about geography on the enforceability standards?
Oh, yes. So geography in terms of what geographical area you can prohibit employees from competing against the bank would be essentially where your bank operates, where your customers are located. So we're here in Polk County. If your customers are solely in Polk County, you'd want to limit the restriction to just Polk County. Now, if they're statewide, we could go all the way statewide. But it needs to be tailored to where your people are located.
Absolutely. And, you know, this gets a little complicated when banks have branches at different places and overlapping, and you kind of go by where the employee works, and sometimes you move employees around to different locations. So you have to be really careful about how you draft these non-competes and the geographical area that you're trying to protect. You also have to worry about whether you're going to do it as the crow flies or driving distance. I prefer driving because it's easy to put it into MapQuest and figure out how many miles they are apart. Just lots of little things you have to think of. Now with the non-solicits, you're substituting in, you're taking geography out of it, and you're substituting in the customer or the employee. So no matter where the customer is, no matter where the employee is, you're protecting that customer. It doesn't have to be just the customers within a particular geographic range. In fact, I recently had a non-compete that came from a new hire for one of our bank employees, and that agreement was written really weird. The non-solicitation had a non-compete geographical restriction to it, as well as a client restriction, and it was really hard to interpret and figure out how it was going to apply. So opposing counsel and I got into a discussion over it, and I told her how we were going to apply it. She was going to get back to her bank and get back to me. That never happened. I poked her a couple of times, and when it didn't happen, I just said, we're moving forward with what I told you. And we've done that, and so far, no harm, no foul. So, you know, there's a lot of these restrictive covenants rolling around out there, and you may see them from applicants and think, oh, this is cool and this is short, I love it, I'm going to use it with other people. Beware. There are a lot of bad restrictive covenants out there, so I really recommend that you get to competent counsel who knows employment law to review them for you and draft you what you really need.
Yeah, and on that note, outside of the financial institution arena, I recently reviewed a restrictive covenant for an Iowa company, and it said that Delaware law applied, but there was no connection to Delaware, so it was clear that the person had literally gone on the internet and then just piecemealed together an agreement, and that's not a good idea at all. Because I don't know what Delaware law is. I can look it up, of course, but we don't want to be fighting something under Delaware law when we're in Iowa.
Yeah.
So make sure you're having legal counsel review those as well. Okay, so I think we can go ahead to the next slide.
I think so.
Yeah. All right, how does a bank enforce its policies or restrictive covenants? So the steps leading up to a lawsuit. So let's pretend an employee leaves your bank or financial institution and goes to another financial institution. You call us up. What is our first, Jill, what is our first thing that we do?
Well, the first thing I would recommend is that if you have a restrictive covenant with an employee, when they leave, you should, at least on the last day, if not before, give them a copy of it, remind them about it, tell them you intend to enforce it, remind them of their restrictions. I can't tell you how many employees have forgotten that they signed a restrictive covenant years and years and years ago, or they think they never signed it, and you do have to have a signed copy. I have had plenty of financial institutions hand these things out with new hire packets and then never follow up and get them back. And then at the end of employment, they have a problem with customers leaving and following them. Well, I've got an agreement. Well, you don't. If they haven't signed it, you can't enforce the contract. So the first thing I want to say is, show me the money, show me the signed contract. Did you remind the employee about it? If not, we can send reminder letters and cease and desist letters to kind of get the process started. Sometimes my clients know the other bank, know the other financial institution, and want to kind of try to handle it by themselves without lawyers. I always encourage that. If you think you can do that, it kind of keeps the DEFCON level down a little bit. And if you can negotiate something yourself, great. But if not, if you want the big hammer to come in, we'll be your hammer.
Yeah. And I think, we were just talking about enforceability of restrictive covenants, and like we said, they're enforceable in Iowa. But if you go too far with the geographic region on a non-compete, or too far with how you define customers, we would come in and step in and say, look, they're going to have an argument that what they're doing is lawful because this portion of the restrictive covenant is unlikely to be upheld by a court. But yeah, we usually try to send a cease and desist letter to kind of get the ball rolling.
When we say restrictive covenants are enforceable in Iowa, we mean good restrictive covenants.
Yeah.
We mean ones that are properly drafted.
Right.
Ones that are not properly drafted, following enforceability standards, are not going to be enforceable.
Yep, exactly. So let's say the employee gets the cease and desist letter. So does the other financial institution, because that's something we do, is we CCC the other financial institution on the letter so that they're aware of, hey, you, financial institution, can be liable for this employee breaching this contract. Let's say both of them ignore it. Jill, what do we do next?
Well, that's up to you. I mean, the decision is up to you. So we can either send a second letter, we can try to call them and contact them, or we can start drafting the lawsuit. And that is going to take a lot of work. We're going to be doing a lot of digging, having you do a lot of digging for information, because the lawsuit's going to include a motion for a temporary injunction. And we're going to need affidavits about what happened. We're going to need to dig into your handbook, into your IT systems, what they did in their emails. We're looking for all kinds of evidence to shore up this potential lawsuit and be ready for an injunctive hearing. Yeah.
And if we don't have a restrictive covenant in place and they've left and you think they've stolen your confidential information and trade secrets, we often recommend, well, we need some evidence of that. So do a forensic audit either internally or hire an outside company to do that so that we have evidence in order to actually file a temporary injunction in a lawsuit.
Employees often forward emails to their home email address or their spouse's email address with all kinds of company information attached to it. They also, be aware of this, take photos of their screens. So I had one case where a mortgage loan officer pulled up every customer record that the financial institution had and took a photo on his phone of it, and had over 900 photos on a flash drive. And when he went to his new employer, he flipped the flash drive at his new assistant and said, here, put all this information into our database so we can use it for marketing purposes. And the assistant, luckily, I think maybe because it would be a lot of work, brought it up to the attention of her management, and her management said, what we recognize this is confidential information and trade secrets of another financial institution. And this particular bank president called up the former employee's bank president, revealed it, turned over the thumb drive to us. We were able to negotiate a great settlement, and that employee lost his new job. Plus, he paid our client $35,000 to cover the costs of what it cost us to research this, to have attorney's fees, to interrupt the bank's operations. So one of my pointers is know your fellow bankers, be friends with them. If you see confidential information and trade secrets coming in from a new hire, you need to stop that right away. And if it's overwhelming, like what we saw here, you're going to need to step up your efforts.
And in our, the restrictive covenants we draft even put a provision in there requiring the employee to disclose prior restrictive covenants they had with a different financial institution. So Jill, would you recommend when a bank hires someone to ask if they have a restrictive covenant?
Yeah, absolutely.
Okay.
And they might have more than one. Because these things last for 1, 2, even if you want to really push it up to 3 years. So they may have had several different employers and they're under different restrictive covenants. And I find that new hires and applicants often don't reveal that right up front to you. And if you never ask, it's like, don't ask, don't tell, I won't tell you. So you want to affirmatively ask whether they have any other ones to make sure that, have us review them. So can you comply with that? Is what you're going to hire this person to do going to fit within the restrictions that they have with other financial institutions?
And let's say that employee does disclose it, but says, oh, I had an attorney review it.
Right.
It's not, the attorney says it's not enforceable. That does not stop your obligation. You should have your own legal counsel review it to make sure you're safe. Because one thing we haven't talked about yet is the fact that you as a financial institution who hires someone with a restrictive covenant and you knowingly violate it, you are on the hook now too.
Right, exactly. Yeah, that is so smart. Never rely on somebody else's attorney's opinion. There's a lot of attorneys that don't specialize in this practice who are just going to say, oh, those things aren't enforceable in Iowa. Never rely on that new hire's opinion or the opinion of their attorney. Get your own review of it and have your own opinion.
So let's go back to talking about forensic audits. Usually what I do is I first tell the bank to try to do it internally. So go through their emails, put in some keywords and see if you can find anything that way. If not, and you're still convinced that they took something, then hire an outside firm to conduct a forensic audit. But beware, because what that forensic audit may show is different than what actually happened in reality. So you need to work very closely with that forensic audit firm to make sure what they give you is actually what happened.
Another thing you can do is you can download that employee's entire email, especially if it's Outlook, to a PST file, and you can send it to us, and we have a product that we use for e-discovery where we can put it in and we can do all kinds of more complex searches than you can just do from your own IT folks to find information. We will have to work with you, however, because we don't really know what the most important information is or who the most important people are or who, Joe Blow is that they sent something to. So we will work with you to, do these searches of time and to and from and who was BCC'd, and we dedupe it, we take the strings, get the emails all in one string so that it really does condense that research process. So I highly recommend that to you. It's been a real help for us in these cases.
Yep. So, this is obviously a very expensive process, and why the heck do we want this information before we're going forward with the lawsuit, Jill?
Yeah, because the burden of proof is on us if we're bringing the lawsuit. So we've got to have the information. Plus, if we bring the lawsuit and we find out it's a wah-wah, there's nothing there, now you've got egg on your face, right? So you want to really do your homework on these things.
Yep, exactly. So we do need some evidence of wrongdoing in order to actually proceed forward with a temporary injunction and then a lawsuit. So let's talk about the pros and cons of a lawsuit. Con would be it's very expensive.
Yes.
Takes
Takes time.
very stressful. It takes a lot of your resources from the bank, testifying, collecting information.
Reviewing information. Yep. It also can sometimes put your customers in the middle. And most of my clients, bank or not, do not want to get affidavits from their customers or have their customers come to testify at an injunction hearing or a trial about who solicited whom, how they ended up moving their business from one bank to the other. Without that testimony, sometimes you if you don't have a showing that they took confidential information, you're sort of dead in the water.
Mm-hmm. Or a showing that they're actually breaching the non-compete,
right.
too.
Right.
And that may be the easiest thing to show is the non-compete.
It is. Yeah. It's the hardest thing to enforce,
yeah.
though. Juries and even judges just don't really like stopping people from working somewhere. So that's why the non-solicit is great to have in the background, because they're way more interested in enforcing that piece than the non-compete.
Yep, absolutely. Now, a pro to a lawsuit is you're protecting your customer relationships, you're protecting your confidential information, you're also starting to set a precedent that I'm going to enforce these agreements. Because Jill, what happens if you have a practice of not enforcing them?
Yeah, all these agreements are kind of like a house, and if you don't enforce each one when you know of wrongdoing and you know someone has violated them, it weakens the whole structure. And what's going to happen is the next employee that you do want to enforce it against is going to point to all these other employees, and discovery will ask, have you enforced these with other people in the past? And if you haven't, the question becomes, well, then they're not really that important, are they? Why would you enforce it against me now?
Yeah. Jill, how many times have you gotten to trial over?
Never.
Okay.
I have had a couple of injunctive hearings that have lasted a full day with evidence and witnesses coming in and that kind of thing, but I've never gotten to them. Usually they either stop at the injunctive stage, whoever wins there kind of has all the power, if you will, or they stop before that. I have had some good results on some of them. We had one where there was a significant amount of information taken, including a cybersecurity breach, which, that's not necessarily our area, but we certainly deal with it, and John Landy and our folks get involved in that, where we got a $375,000 award, a settlement. I've had some that settled for $35,000, $7,000, $12,000. And then I've had some that really went nowhere. I've had some where we settled not for any money and we just kind of jiggered with the terms of the agreement and got it narrowed down to what the bank really needed rather than the bigger piece of what we wanted at the beginning.
Yeah, and the settlement is good because you can avoid the trial altogether, but you may be able to collect your attorney's fees, kind of what Jill's hinting at when you get money. That's another important reason to have a restrictive covenant agreement, is so that you are entitled to attorney's fees if you prevail in the action. So our time is up.
And we're at the end.
And we're at
perfect.
The end. If you have any questions, feel free to email Jill or myself, and we'd be happy to help you out.
Thank you. Oh, it's time for a break now, isn't it?
Oh,
Did we tell them
oops.
that?
We're still.
Welcome back, everybody, to the Dickinson Law Banking Seminar. We have a couple of more sessions for you before we send you off into your lunch break, and we're going to call this little segment the David Doubleheader. It's going to be myself, David Gonzalez, and then David Wetch talking about a couple of compliance-related issues to try to help out your banks in a couple of different situations. For the next half hour, I'm going to talk about changes in bank control, and this is a change in bank control at the holding company level. Now, you might be thinking, I don't own a bank, I'm never going to own a bank, so why does this matter to me? It matters to you because banks are often asked to help out when someone is acquiring bank stock at the holding company level to provide the information that's being requested by the Federal Reserve. And I am going to talk about just the Federal Reserve filings in this time period, because even though there is a state regulatory administration that happens simultaneously with the Federal Reserve, it kind of happens along the side, and we only have enough time to really cover the federal filings, because the federal filings is really where most of the action happens. This process can feel very cryptic, and I've given you an example of something that can feel cryptic, that if you know the keys, can be deciphered very easily on the slide that I've given you right here. And you look at this and it doesn't seem to make any sense. But if I give you the keys, if I give you the information you need to decipher it, if you knew that, for example, the Greek symbol delta is commonly used for change, I think most of you are bankers and knew that already. Now the second half might be a little bit tougher. You probably have to know a little bit about 90s pop music to recognize that that other symbol there is the album cover from Janet Jackson's Control album. So all this really says is change in control. That's what we're going to be talking about. Why is this a topic at our banking seminar? Why did we think it was important enough to spend a half hour talking about it today? It's because these filings are increasing dramatically right now, and there's a handful of factors that are increasing these filings. First, just as we got to the end of the pandemic, the frequency of bank mergers and acquisitions has started to pick up. And it's not just that it picked up to its normal pace. We're kind of accounting for all of those mergers and acquisitions that might have happened over the past year. And so that frequency of acquisitions is really, really high. Also, sometimes there's some advanced estate planning tools. We're going to talk about trusts a little bit later on in this talk and how they affect this process. These trusts are often the owners of bank stock, and that comes with its own special issues that we will get into a little bit later. There's also tax planning that some people are doing. There is a lot of concern out in the world that possibly the unified credit, which has been $11.6 million for quite some time, may be lowered by the current administration. And so people are trying to take advantage of that while they can right now. And by doing so, what they're doing is giving these gifts now while they're alive and passing on some of the value of this bank stock to their kids or their grandkids now, and that's causing them to have to make these filings. And then finally, the other reason that these happen are remedial filings. Instances where a change of control filing should have happened at some time in the past. Maybe it's 6 months ago, maybe it's 4 years ago. But either way, we've missed that window and we have to go back and get that change of control and get that approval from the Federal Reserve. So that's what we will be doing. I'm going to cover a handful of things in this talk. We'll talk about when we're going to have to file these changes of control. We're going to talk about some of the important definitions. Some of those definitions you'll see coming up. A couple of other ones that are later on will be presumptions of control, or concerted action is going to be a big thing later in the talk. We're going to talk about the timing of the filings, when we have to file before the change of ownership of the bank stock and when we're allowed to file after. We're also going to talk about some of the informational thresholds. That gets into the discussion of when do I have to file these change of control filings. In some cases, there might be some bank stock that's sold that doesn't require a bank stock that doesn't require a change of control filing, and we're going to want to know that before it happens. And then finally, those special considerations for trusts. There are some special requirements that allow us to have trusts own bank stock without them being considered bank holding companies in and of themselves. And we will get into how that works and how to prevent any headaches that might come from that in your change of control filings. Next, the consequences. So let's say we don't file these change of control filings like we're supposed to. What could possibly go wrong? Well, there's a handful of things that go wrong. First of all, if it's a willful violation, if you knew you needed to file these change of control filings, the violation penalty could be $100,000 per day of the violation. In other words, once that bank stock has been transferred to the new owner, they knew that they were supposed to file a change in control, they chose not to, that's $100,000 per day of the violation from the moment that bank stock changed hands until that is remedied. That's the maximum penalty, of course, and then of course there's up to a year in prison. Other violations, if you were intending to deceive, that could be up to $1 million per day of the violation, and that can be up to 5 years in prison. So those are the more egregious types of violations of the Change in Bank Control Act. Some of the lesser end, now if you're just participation in a violation, maybe you didn't realize you were supposed to file, there's still some civil money penalties for that, and that's up to $25,000. Again, these are penalties per day of the violation, so it does not take very long for these to add up. Let's get into a couple of definitions that are going to be important for us. First of all, a bank holding company. Any company that has direct or indirect control of a bank. So, everybody thinks of just, a larger bank corporation that's holding the stock of, or 100% owns the subsidiary bank. That's what you think of. But it is much broader than that, because the definition of company includes any bank, corporation, general or limited partnership, association, similar organization, business trust, or any trust or any other trust. Never mind if it's a business trust or not, it could just be an estate planning trust, unless by its terms of that trust, it must terminate within 25 years or within 21 years and 10 months after the death of the individuals living on the effective date of the trust, and all of you just went to sleep. If any of you out there have ever been to law school, that last portion probably sounded familiar, and I'm sorry for the blackout you're about to have when I say that sounds a lot like the rule against perpetuities, and that is on purpose. It is very similar, but not exactly the same, and when we talk about the trusts at the end, we'll talk about how some things that you would normally include in an estate planning trust will help us get the trust out of that definition of company and thus out of the definition of bank holding company. The next thing we have to talk about is what is the presumption of control? Who has control of a bank holding company? It's ownership with the power to vote. Now this is the voting interest of 25% or more of any individual class of voting securities. Usually there's only one class. If there's more than one class, you might have a couple of different people who had some control, or a couple of different groups that had control. There is also a rebuttable presumption of control within the regulations if you have a power to vote 10% or more of any class of voting securities, and then there's no other person who owns, controls, or holds power to vote greater percentage. So let's talk for a second about how that breaks down. Let's say you own 12% of a bank holding company, and you have that presumption of control, but only if there's nobody else who's not in concerted action with you who doesn't own more. So if you own 12% of a bank holding company, but another shareholder owns 30% of that bank holding company, you with your 12%, unless you're part of a family group, is not going to be deemed to be in control of that holding company. Okay, now with the definitions underway, we can actually get into, hey, let's buy some bank stock. The control acquisition. So you're going to be buying some bank stock. How much? Maybe you're buying the controlling interest. If you're going to purchase it, if it's going to be assigned to you, if it's being some type of transfer, a pledge of the voting securities, or just an increase in percentage of your ownership. Let's say you already own 5% of a holding company and you're going to get another 20%. Now you're acquiring control. If you are in control of that, you need to give 60 days notice in advance of when you take possession or take ownership of that bank stock. If immediately after the transaction, you, the acquiring person, or some persons acting in concert, we'll talk about that in a second, will own, control, or hold with the power to vote of 25% of any class of voting securities. We just talked about that. That includes those presumed to be acting in concert. So who's acting in concert? What's concerted action? The company, if there's a company, that company and its controlling shareholder are considered to be working together. If there's an individual, your immediate family, so that would be your spouse, your children, your grandchildren, any in that immediate family, that's going to be part of, you're going to be considered to be all acting together when we figure that 25% percentage. Companies that are under common control. Parties to any agreement other than a revocable proxy. So if it's just a proxy, we talked about these securities being voting securities. Maybe you've given a proxy to somebody to vote on your behalf. As long as that's revocable, that's not a change of control. If there's an individual person and that person is the trustee, the person and the trustee are working together. And then what all of this creates are what are called control groups. So these people that are acting together, so an immediate family group would be a control group. A trustee and the trust that they control. The individual themselves and the trust that they control. They're working together. That's going to be concerted action. So all of that is considered when we're thinking about that 25% or that 10% presumption of control. If you are determined to be in concerted action, if the regulations say so, you want to consider, are you already part of an existing control group? Has this group of people, have you as an individual been approved as part of a group? Or is part of this group already approved? Or are you just applying to be a part of the group? So let's say, for example, we've got a family. We've got a husband and wife. The husband owns 50%. The wife owns, let's say 40%, so that's 90%. And now they've given some stock to their kids. Let's say, for example, they have 3 children. And for whatever reason, one of the children, they only give 1.5% of the bank. Well, that is not going to be enough of an ownership stake in the bank for that particular child to be required to give some extra information to the Federal Reserve to apply to be part of the control group. It's going to be a 2% threshold. So we've got the 25%, that's for the overall group. Now we're going to look at what is your individual ownership percentage. Is it more than 2%? If it's more than 2%, you are going to have to file with the Federal Reserve an interagency biographical and financial report. It'll have your individual financial information. There will probably be follow-up questions along with that. It seems to me every time I work on one of these, there are. We've had 4 of these come through our office so far this year. A good year, we usually see 1, so that gives you an idea of just how much the frequency of these things has increased. Now back to that individual ownership. If you're not across that 2% threshold, you don't need to worry about it. Once you cross that 2% threshold individually now, you're going to have to file that IBFR. Once you pass the 5% ownership threshold, now you're going to be required to give even more information in addition to the change of control filing. The interagency biographical and financial report, I've got the form number on there as well on the slide. You're also going to be subject to fingerprinting, and there's going to be a background check that the Federal Reserve is going to conduct on you. So when we talk about those gifts that I was talking about earlier on, if you're giving gifts to children or grandchildren and they're going to pass these thresholds, you want to let them know in advance, hey, these types of things are going to be asked of you. This is the type of information that you're going to be asked to provide in the change of control filing so that they're not caught unawares at the time that that change of control filing actually does happen. Now, there are some exempt transactions. There are times when stock will change hands and there's not going to be a change of control required. Acquisition of additional stock. Let's say you already own some stock, you own 1%. and maybe you're individually going to get another 5%, but you're not part of the control group. That acquisition is not going to be required. That acquisition is not going to require you to file a change of control. If you've got additional stock, when you've continuously held more than 25% since March 9th, 1979, when the regulation went into effect, so you've owned the stock for a really, really long time, you're near retirement, and maybe you've owned 50% of the bank, and now you've decided to buy another 25%. If you've owned it since March 9th, 1979, you're not going to need to file a change of control. That's already taken care of. If there's an increase of previously authorized acquisitions, you've already done a change of control. Let's say you're part of a group that owns 55% of a bank. You own 5% of it now, so you've already crossed that threshold where you had to provide all the extra information. The fingerprinting has been done, the background check has been done, and now you acquire another 5%. There's no need for an additional change of control filing in that case. Proxy solicitation, I talked about that a moment ago. If it's just voting in the annual meeting of the holding company, and it's a temporary proxy, we don't need a change of control filing for that, and you don't need a change of control filing for stock dividends. The common theme of all of these things is that the overall control of the bank holding company is not really changing. And that's really what the touchstone of this portion of the regulation is. Now, there's also some times where a change of control notice a filing is required where we don't have to do it in advance. We get a 90-day window after the transaction has occurred. You'll see a common theme once I get into these things, but let's kind of go down the list before we get into why. First, acquisition through inheritance. The majority owner of the bank holding company has passed away, and they have given the fruits of their bounty to their beneficiaries of their will, or their descendants, or their heirs, whatever it is. If it's an acquisition through will, it's not that the filing isn't going to be required, it's just that you're going to have some extra time. Acquisitions through bona fide gifts. Again, someone decides that they want to use up their unified credit now, rather than waiting until they have a will or they pass it on through a trust or some other mechanism. If they want to give that gift now, and you don't have control over when that gift is given, and you're the receiver, that change of control, again, it's still going to need to be filed, but it's not going to need to be filed in advance of the gift. Acquisition as satisfaction of debt previously contracted. Maybe somebody, you've given somebody a loan against their individual bank stock, and now they're using that bank stock to pay off your loan. You didn't know that that was going to happen, obviously, so you're not going to have to give advance notice to the Federal Reserve. You are still going to have to give the Federal Reserve notice. Acquisition through redemption of voting securities. There's different types of convertible stock. If you're redeeming, there's no advance notice for that. And then acquisitions by actions of a third party not in control of the acquirer. So, what do all those things have in common? All of those things have in common that the person acquiring the stock does not have control of when the transfer occurs. They're not buying it. They are being given it by someone else, by the current owner of the stock. And because you don't have advance notice of when you will receive that stock, of course, the regulations give you some leeway to provide notice to the Federal Reserve, and what that time period is going to be 90 days from the time the transfer occurs. So when the stock does come to you, that's when you're going to want to start working towards getting that filing. I would advise you not to wait till that 90th day or till the 80th or 85th day. These filings do take some time, and when we talk about some of the hiccups that'll happen, what goes wrong with these type of filings at the end of the presentation, you will see just why we want to start that process as early as possible. So as soon as you know you're going to be acquiring some bank holding company stock, you want to start thinking about this process. So let's turn our attention now to trusts for a minute. I read that really complicated definition earlier on of what constitutes a company, and then of course that definition feeds into the definition of bank holding company. just to make it, as confusing as possible within the regulations, a definition within a definition. So what we're trying to do is make sure that the trust that is going to be holding the bank stock is not deemed to be a company under the regulation. So what are those criteria? The trust has to terminate, and this is the one really that we have most discussion about. I get the most additional information requests from the Federal Reserve when we handle these type of filings about this first issue, and that is that the trust must terminate within 21 years and 10 months after the death of the grantors or beneficiaries of the trust living on the effective date of the trust, or and this is a separate or, within 25 years. So what does that mean? Let's say, for example, you own bank stock and you've put it into a revocable trust, and the trust is now applying with the change of control to say, it is owned by the trust, here's who the trustee is going to be. That's who's really going to be in control here, is the trustee. How do I make sure that we don't deem this trust as a bank holding company? The provisions of the trust will need to talk about when it needs to terminate. When are we dispersing the assets? When is it no longer going to be held in trust? And usually that's going to be pretty soon on the heels of the death of the grantor of the trust, or so that it gets distributed out to the beneficiaries. There's a definition within Rule Against Perpetuities. Again, I've got people blacking out or blocking out their years of law school from that, where it just says, when this trust was created, can we kind of point to these are the individuals who are going to be receiving it, and at some point within 21 years of the end of a life, are they going to just get the stock? It's not going to be held in the trust anymore. We are really trying to prevent kind of a perpetuity type of situation where this bank stock just stays in trust forever and it doesn't get back kind of into the stream of commerce. That's what this is trying to prevent. And the same with the 25 years. You can use 25 years. I will tell you that it is much more useful to try to deal with that front end of the definition, because there are some standard provisions in estate planning trusts that meet that definition once you go ahead and explain them in plain English. Second, the trust has to be established by an individual or individuals for the benefit of natural persons related by blood, marriage, or adoption. So the beneficiaries of the trust are not going to be able to be friends. They're not going to be business partners. It's to pass along to your family. That's the type of trust that is going to qualify to get out of the definition of bank holding company, to keep away from additional filings required. The contents are only assets owned by the individual or individuals who establish the trust. This is where it gets complex. Not only is it going to be an issue that the grantor is going to have to be the one who own these assets, who own the bank stock or whatever else is in the trust before it was put into the trust, but the composition and what types of assets are also going to matter. There's going to be a small percentage of assets in the trust that are not going to be of issue provided they don't hit a certain threshold. Some things that typically aren't concerning are cash or cash equivalents. If you've got bank stock and then maybe there's an IRA or a life insurance policy, depending on its size, or some cash or cash equivalent within the trust, that's usually going to be okay. What becomes a problem in Iowa is that if this really is an estate planning trust, owners of bank stock also own other assets that you might typically find in the Midwest. For example, farm and farmland. And the appreciation of farms, the appreciation of the value of farmland, when you start looking at how much of that trust is the bank stock and cash equivalents, if that farmland is valued too high, what we end up having to do is spin off a mirror trust. We'll talk about that again a little bit in the next slide. The final two things: it can't be a Massachusetts business trust. almost none of them are. That's really, I've never seen that be an issue. It would be very surprising. That's the type of trust that would issue shares. So that's that fifth bullet point there, does not issue shares, certificates, or any other evidence of ownership. This would be the type of trust that maybe is a real estate investment trust or something like that. That's not going to be okay to own bank stock. That's not going to meet the testamentary trust exception. If we meet all these conditions, it's not a company. That's the important thing. So then what if a trust doesn't comply? What if we have some of these assets that the value of some of these assets are just too high? Well, then we have to spin off what's called a mirror trust. It will have exactly the same dispositive provisions. It'll include any missing provisions if the Federal Reserve requires. For example, if it doesn't terminate soon enough, we can include that. It cannot hold more than 25% non-bank assets. And that's that farmland problem I was talking about. If the value of the farmland is really high, we're going to get over that 25% threshold pretty quickly. It is allowed to hold bank stock. It's allowed to hold cash and some cash equivalents. So that mirror trust will, again, it'll primarily be just for the bank stock. There may be a handful of other assets that will be permissible. We want to watch out for the value of those. May or may not need court approval depending on the type of trust. Finally, what if the trust is irrevocable? I like to say, and I probably shouldn't say it on a recording, saying a trust is irrevocable just means you need to get more people's signatures to change it. So finally, wrapping up, what goes wrong in these type of filings? First of all, publication problems. One of the problems we had on one of our most recent filings was that we had trouble because the publication had to happen in the county where the bank was located, where the subsidiary bank was located. It was such a small paper, we had troubles getting the affidavit back from the paper. That became a very big problem. What if there are underlying issues with a subsidiary bank? That can cause a problem with a change of control filing. Additional document requests. This will happen almost every time with a change of control filing. There will be additional information that the Federal Reserve will request. Typically, your attorney can help you out, provide those additional explanations. You might need to provide a couple of additional documents, depending on whether it's in relation to the change of control paperwork or those IBFRs, the biographical and financial reports. And then sometimes there's just additional required representations. Maybe you need, the Federal Reserve will require you to, as the trustee, represent that it will terminate in a timely manner in accordance with the regulation. Those are very easy to put together and very easy to fix. What else goes wrong? Yes, more things than just that goes wrong. Sometimes, some of us have gotten really, really used to paper. The Federal Reserve will not accept any of these filings in paper form anymore. It has to be done online. And so you need to be prepared for the fact that these are going to be electronic filings. That's even been an adjustment for me. I like paper as much as almost anybody else. There might be one person talking later who likes it more than me. Uncooperative co-applicants. We talked about those control groups. Once people have crossed that 5% threshold and they need to submit the IBFRs, they need to submit their fingerprints, they need to submit to the background check information, there may be some people who really don't want to do that, who are part of an ownership group. So we really need to think about that in advance. Are we going to have troubles getting this type of information from some of these people? How do we make them more comfortable? How do we assure them that all of these filings are secure, they are confidential, to help them along and cooperative? And then the final thing that I will say goes wrong is, I said trustees are in control for trusts. Sometimes you got a trustee that really wants to be active and really wants to get something done or go very, very quickly. And that will often just cause problems because the facts of your filing will change in the midst of your filing while you're waiting for approval, and that can be problematic. What can you do to prevent them? Talk to an attorney before you make these filings. It's very important. They will help you prepare, and they will ease the process significantly. Be sure anyone who's receiving a gift is prepared to submit the information we talked about to the Federal Reserve. If a trust is going to be involved, again, if you reach out to your attorney, often you can reach out to the Federal Reserve and they can review the trust in advance to see if it meets the testamentary trust exceptions. And if it doesn't, then you can make changes before that transfer happens. And then finally, be patient. These filings do take time. I said 4 of these have crossed my desk over the past year, and of those, 2 of them have been completed. It just sometimes takes a while, a lot of exchange of information to work yourself through. If you have any questions, certainly feel free to email or call my direct line. That concludes my time today. I really appreciate all of you joining us on the bank seminar today, and I will now hand it over to the much more exciting second half of the David doubleheader before lunch, and David Wetch will talk to you about powers of attorney, a subject that is near and dear to both his heart and mine. Thank you.
Good morning. My name is David Wetch. David Gonzalez, thank you for that introduction. I don't think this is as exciting as what he has made it out to be. When I was asked to be a presenter today, I was asked to also pick a topic. And David Gonzalez and I routinely respond to various compliance requests or inquiries made by various financial institutions in the Iowa area. And over the past year and a half, we've had an increasing number of inquiries about dealing with powers of attorney. And I thought for a moment as to why this is, because I've been doing this for 42 years, and I probably have had more inquiries about powers of attorney in the last 2.5 years than I had in my previous career. And I think it's a combination of factors. Certainly COVID has contributed to this, but our aging society has also contributed to the numbers of powers of attorney that are routinely being used. And most of this outline is more for your compliance staff than it is for the people that are probably listening to this. But it's important to understand some of the things regarding powers of attorney so that you can explain to your regulatory and compliance staff the importance of what you're dealing with. What is a power of attorney? Let's start with that. A power of attorney is a very simple document that designates an agent, a third party, signed by an adult, that then gives the agent authority over certain aspects of the principal's personal and financial affairs. What types of powers of attorney are there? A durable power of attorney is probably the most common instrument you're going to see. And since Iowa adopted the Uniform Power of Attorney Act, which is Chapter 633B of the Code of Iowa, that is now an actual legal form set forth in the statute. And on the bottom of page 2 of my presentation, I provided you with a link that allows you to go to the form itself, but also the entire contents of Chapter 633B, which is the Iowa Uniform Power of Attorney Act. That act was adopted in 2014. So from July 1st of 2014, we've had the luxury of having the Uniform Act, which is much more comprehensive and explains a lot of the details and answers a lot of the questions you might otherwise have. Very simply said, a durable power of attorney is a document that is generally effective immediately, and it is not affected by the incapacity or disability of the principal. And that's generally the very reason that the power of attorney is created. The individual, the principal, wants to designate somebody to be able to act on their behalf if at some future date they become incapacitated. Sometimes that power of attorney is not effective until a physician certifies them to be legally incapacitated or disabled. Although as a practitioner, I recommend using that, against using that format, as it is nearly impossible to get a doctor to certify that a principal is actually incompetent. If they use the statutory durable power of attorney form that's set forth in the statute, the good news is, unless it specifically states otherwise, that power of attorney form is effective immediately and it is not affected by the disability or incapacity of the principal. A springing power of attorney is a durable power of attorney that is not effective until a certain event occurs. And generally it's the mental disability or incapacitation of the principal. But again, that requires a certification of a physician, and that's often very difficult to obtain. When does a power of attorney terminate? So the power of attorney is effective until either the death or that the power of attorney is revoked. And again, you need to understand that, and your compliance people need to review the power of attorney to determine A, when it becomes effective, and B, when it terminates. Under unusual circumstances, I'll see powers of attorney that are prepared for a very specific act, and they may only be valid for a specific time period. And again, reading the power of attorney will tell you that. What powers does an agent have? As to that aspect, the agent only, I repeat, only has the powers granted in the instrument. And again, that's why it's so important to read that instrument to determine what specific powers they have. If it is not in the power of attorney, they don't have the powers, very simply stated. However, if they reference under the new statutory power of attorney, the durable power of attorney, they can reference the provisions of the Iowa Code, which, let me get the code sections, and I believe it's 201 to 217. They then have all of the authority specified. But on the statutory form, there's actually a list of powers granted on page 2, and the principal can either check each individual box that they want to grant the authority, or in the alternative, the last selection is all preceding subjects, which gives them all of the above. In addition to that, there are certain very specific powers on the general power of attorney form or statutory power of attorney that has to be specifically granted. Those include things like terminating a trust, amending a trust, making gifts, or the most important one is delegation of authority. If the power of attorney does not specifically have that provision, the agent is prohibited from delegating any authority under that instrument. Does a power of attorney need to be recorded? The answer to that is no. However, there are certain instances where that's an exception to that. And the most common one that financial institutions regularly deal with is when it comes to real estate. If the agent is doing anything pertaining to real estate, quitclaiming the property, mortgaging the property, whatever that might be, that power of attorney form must be recorded in the county of the property being located. So for example, if we're dealing with a farm, it's in Madison County, the power of attorney document needs to be recorded with the Madison County Recorder's Office. If the farm is in Dallas County, it has to be recorded in Dallas County. If it's in multiple counties, which often occurs, we recently had a transaction that was in both Dallas and Madison, you have to record it in both counties. And the idea being that that document then shows up in the abstract of title that will then demonstrate that the agent designated had authority to execute that instrument. If you're using powers of attorney for home mortgages, whether that's a first mortgage or a home equity loan, you need to check with what your internal policies and what also the policies are of your buyers on the secondary market. There are some secondary market purchasers of mortgage that will not accept a mortgage when it's executed as via an attorney, a power of attorney. So you need to know those restrictions before you proceed. Home equity loans are another special item, and more often than not, the home equity loan procedures require that the borrowers execute those documents in the presence of a mortgage banker. And if that's the case, then you can't use a power of attorney. Safety deposit boxes. Under the Banking Statute and the Power of Attorney Act, the power of attorney, the agent specifically has authority to access safety deposit box. For maximum protection and just good policy, if there are multiple owners on that box, I suggest that you either provide notice to the co-owner of the box that someone is accessing the box, or at least at a minimum, verify that the safety deposit box agreement authorizes one of the principals to designate an agent to so act. Powers of a beneficiary, a payable on death beneficiary on a joint account. Under the statute, an agent can open a bank account if it's so designated, and if the agent is a relative, descendant, or spouse, then that individual can designate themselves as a beneficiary on the account. And on that, you just want to read section 633B.201 of the code. Under the old act, that would have been construed as self-dealing and prohibited, but now that is permitted under certain circumstances. Acceptance of powers of attorney. Are you required to accept a duly executed power of attorney? And the answer to that is generally yes. And in fact, under the new statute, there is liability to the person that is improperly rejecting the power of attorney. But at the same time, the financial institution can take certain safeguards to protect the financial institution from liability. Another question I often receive is, do the bank or the financial institution need the original power of attorney? The answer to that question is no. A copy, either a copy or an electronic transmitted copy, is acceptable. Similarly, the general power of attorney does not need to be recorded unless you're dealing with real estate. So, how do you protect the bank? There's a very, very simple procedure that you're authorized to request under the statute, and that is to either request an opinion of counsel, and that letter or counsel is from the attorney for the agent, and that's at the agent's expense. And that's basically the agent's counsel certifying as to the validity of that power of attorney. In the alternative, you can also request a certificate from the agent. That certificate is actually in the statute. It's under Section 302 of the Act. But by obtaining that certificate, you then can demonstrate that you've made the request, you have that certification, and with that in your file, you can then act and accept that power of attorney with extremely limited liability. There is a time frame if you're going to question the validity of the power of attorney or whether you're going to accept and reject it. So within 7 days from being presented with that power of attorney, you have to either request the certification or a counsel opinion of counsel, or reject it. And if you request either one of those, within 5 days from receipt, you then have to make a final decision whether you're going to accept or reject the power of attorney. If you reject it, you're required to set forth in writing why you rejected it. And you need to be aware that if you improperly reject a power of attorney, there is liability to your financial institution. And that liability includes both actual fees as well as attorney fees and costs. So you need to exercise some care in just unilaterally rejecting a power of attorney. I've specified the grounds for refusing, but there are limited grounds, and just be aware of that. They're set forth in the statute. So But let's skip ahead. Apologize. So if you accept the power of attorney, do you become liable if the agent misbehaves? And the answer to that is no. And the new Power of Attorney Act actually gives the financial institution or entity accepting that financial power of attorney legal protection unless the person accepting it has actual knowledge that the power of attorney was revoked, or if the agent is acting beyond the scope. Another question that comes up on a regular basis is, can an agent authorize somebody else to exercise the powers granted? That used to be called a substitution of agent. It's now referred to as delegation of authority in the new statute. And that is an emphatic no unless the power of attorney form specifically authorizes the agent to delegate. And if you'll review the statutory form, that actually takes a special election beyond the elections normally provided on page 2. And even if you elect the all preceding subjects option, that would not include the power to delegate. And there are certain special powers that require that specific grant of authority. And those include the ability to make gifts, the ability to terminate, modify trusts, disclaimer, that type of thing. What happens if you get a power of attorney from another state? Powers of attorney the validity of those instruments are determined by the state in which the document is executed. That's usually readily determinable by where it was acknowledged. The notary provision should state the state and county of where it was acknowledged. So for example, if a power of attorney was executed in Mississippi, the validity of that instrument is controlled by Mississippi law. If it's executed in Iowa, it's controlled by Iowa law. The only exception to that particular provision is that if the power of attorney instrument specifically references a law, so for example, if it says that this is going to be controlled by Iowa law, even if it's executed in Mississippi, it would still be utilizing Iowa law to determine the validity and scope of the document. Does the bank need the original power of attorney? Once again, no, but you should obviously obtain a valid copy of it. So now I'm going to review a couple of provisions in the statute. And I'm not going to spend a great deal of time because you can review it at your leisure. Prior to the Uniform Act being adopted, the individual named in the power of attorney was referred to as an attorney in fact. The new statute referenced them as an agent, and that's a much broader term, and it's actually easier to use. But again, that could include the original agent, a co-agent, a successor agent, or a person delegated if that's included. Excuse me? Execution. What requires a power of attorney to be properly executed? Once again, 105 of the Act specifies that. About 6 months ago, I had a situation where the principal had had a severe stroke, was totally incapacitated, but still had all cognitive functions. And so they had gone to a lawyer, and the lawyer had properly indicated that, yes, you can still do a power of attorney. And so in that instance, the power of attorney was executed by a third party at the specific instance and request of the disabled person. And in that instance, the notary simply recited that. That was presented to me for review. I initially had questions. I contacted the lawyer that had prepared it. We reviewed the contents of Section 105 of the Act, and it was obvious that, yes, in fact, that was a valid document. If you receive a notarized power of attorney, there is a presumption that that document is a valid document. But once again, from a liability perspective, I always recommend that you request the agent certification or the opinion of agent counsel. You should understand that an agent acting on behalf of a principal is entitled to reimbursement for expenses actually incurred, but they are not entitled to compensation unless the instrument specifically authorizes. And where that can become relevant, if you start looking at an account and you see transactions where the agent is writing checks out to themselves, it would be prudent to question those transactions to determine why the agent was doing that. What are the duties of an agent? Fairly simple. The agent at all times is a fiduciary, and they're required to act in good faith, but they're also required to keep records of all receipts, disbursements, and transactions made on behalf of the principal. If you become very concerned about the validity of a power of attorney, what can you do? The code authorizes that you can seek judicial review of that power of attorney. From my perspective, that would be an absolute last resort action. But under the statute, section 116, a person being asked to accept the power of attorney can commence a legal action for judicial review. The problem with that approach is, A, it's timely, it takes a lot of time, it takes a lot of expense, and the real problem is that if you lose the case, that the court has the ability to award reasonable attorney fees and costs to the party that wins that particular action. I think a more prudent action is to request the agent's certification or the opinion of counsel, because if you do that and you have that in your file, you have a significant amount of liability protection under section 119 of the Act. Once again, if you improperly refuse to accept a power of attorney, you have liability exposure, and that includes attorney fees and costs. Section 201 through 217 of the Act specify all of the various powers, and they break down more specifically what those powers entail. For example, under a construction of authority, generally it explains under 203 what that includes. Under 204, it deals with real property. Probably the most important one for financial institutions is section 208, and that goes through all of the different acts if that selection is picked of what they can and what they can't do. And those include safety deposit box, those include requesting statements of account, that include contracting for services, opening an account, modifying an account, closing an account, transferring an account. I think I've already briefly discussed gifts. That's under 217, but once again, the power of attorney form has to specifically include that power for it to be authorized. Then 301 of the Act is the actual Iowa statutory power of attorney form. It's very important, I think, for your compliance people to become familiar with the context of that document, familiarize themselves with what it says, so that if they see that, there's some degree of familiarity and they can readily determine how it's being executed, what it specifies. Similarly, the certification of the agent is in section 302, and that is also a form that they should familiarize themselves with. At the bottom of page 2, I provided that link. Feel free to print those documents. So in closing, my suggestion is that you review the document carefully. Read it, determine what it says, what it doesn't say, but always request an agent certification, and if you have any doubts whatsoever, request the agent's opinion of counsel. We're going to break now for lunch. I hope this has been of some benefit to you guys that are listening to this. There'll be a 60-minute lunch break, and after lunch we're going to have a presentation from Brad Cruz on recent revisions to the Iowa Business Corporation Act and the impact on bank holding companies. If you have any questions regarding powers of attorney, feel free to contact me at the site indicated on the presentation, and thank you very much for your time.
Good afternoon and welcome back to the Iowa Virtual Banking Law Seminar. After our afternoon break, hope everybody had a good lunch. Normally we would be in person and have had some good food, but unfortunately with the COVID restrictions, here we are virtual. We're happy though to do it virtually this year. We are broadcasting live from Caesars Palace in sunny Las Vegas, Nevada right now. Wish you all could be with us. No, we are at an undisclosed off-site location. How about that? So, I'm Brad Cruz with Dickinson Law Firm. I'm going to talk today about revisions to the Iowa Chapter 490 and the act that affects holding companies and even banks that aren't operated through a holding company structure. The Business Corporation Act was revised this year. We're calling it a new act. Like the existing act, it is modeled after the Model Business Corporation Act created by the American Bar Association. And it was a culmination of a 3-year project with the Iowa State Bar Association with proposed legislation that became the new act. Talk a little bit about bank holding companies. Here, the new act represents the first comprehensive revision to the Iowa Banking or the Iowa Business Code in more than 30 years. Given the large percentage of Iowa community banks that are operated through a bank holding company structure, the new act significantly impacts bank holding companies. And it also impacts banks that are not operated with a holding company structure. As Iowa Code 490 or Iowa Chapter 490 of the Iowa Code applies to banks in the absence of any contrary authority or contrary provisions under Chapter 524 of the Iowa Code. Just get to some quick statistics. 85% of commercial banks in the United States are operated through a bank holding company structure. Over 75% of small banks with less than $100 million in assets are owned by bank holding companies. And the majority, and I would say probably vast majority of Iowa's community banks are owned by holding companies. Just to give some quick benefits of bank holding companies, just for those out there that aren't or maybe are considering it, for the uninitiated or the parties that haven't done so yet, we would strongly considering a bank holding structure operation. There are many benefits. One is increased ability to generate capital. Small bank holding companies can borrow funds and inject those funds into the subsidiary bank. Furthermore, such borrowed funds are treated as capital of the subsidiary bank and are deductible by the bank holding company. Small bank holding company is free to obtain cash through the issuance of debt from an institutional lender, a banker's bank, a wealthy director, or a variety of other sources. That flexibility is not there in the absence of a holding company structure. A bank holding company provides much greater flexibility in facilitating acquisitions. If a bank holding company acquires another bank, it can merge the subsidiary bank at any time after the acquisition. This is opposed to the situation where a bank-to-bank merger, and when that takes place, that requires the banks to be fully integrated on day one of the acquisition. Not so with a bank holding company merger. And of course, there's greater flexibility for the use of debt in bank mergers and acquisitions. Another benefit to operating under a holding company structure is that bank holding companies may engage in additional permissible activities that are not possible for a bank. This would include the holding of certain problem assets purchased from a subsidiary bank, as well as the ability to own up to 5% of any class of voting securities of any entity without regulatory approval. Furthermore, certain non-bank activities that are incidental to the bank and/or financial in nature, such as securities underwriting, insurance underwriting, and merchant banking, are possible to be conducted through a bank holding company, but not so at the bank level. So enough of that. Let's move on. I threw those things out there. If anybody is interested in finding more about the benefits, advantages, pros, cons of holding company structure, give us a call. We're happy to help with that. Moving right along to the benefits or to the revisions to the Act. I'll just refer to it as the Act. Of course, I'm speaking of Iowa Code Chapter 490, the revisions to that. Now, under the first, there's been some ratification of directors' duties, director liability, and changes, and to those and officer duties as well. I'll summarize those fairly quickly as we move throughout this. With respect to directors' duties, the current Act outlines the duties and standard of conduct for directors, and sets out the standard of liability for directors as well. These are unchanged by the new Act. What has changed is there's a new provision of director liability, which is rather quite interesting, and it relates to the corporate opportunity doctrine, and it sort of suspends that, if you will, for in the case of appointing directors and relating to the liability of directors. The provision specifically in the new Act authorizes a corporation to include a provision in its articles of incorporation that limits or eliminates the duty of the director, of any director, to offer to the corporation the right to a corporate or business opportunity before it can be pursued or taken by the director. So probably you're fairly familiar with the corporate opportunity doctrine. It basically states that a director of a corporation must offer a corporate opportunity or business opportunity to the corporation first before he takes it himself, or he or she takes it themselves, or offers it to another entity that he or she may be also involved with. So this should greatly expand the ability of corporations to get directors on the board and not have to worry about some unclarity or confusion surrounding whether that director, if they're involved with another corporation, another bank, if you will, another entity, if they are going to have problems with the corporate opportunity doctrine. So that expands the trending law and makes it a little more up to date with what's going on in jurisdictions such as Delaware and trending other places. Another major change is with officer duties. Under new section, there's a new section that's been added which assigns a duty to a corporation's officers, obligating them to inform their superiors about the corporation's affairs known to the officer or that was within the scope of the officer's functions, including any actual or probable material violation of law involving the corporation or material breach of duty by an officer, agent, or employee of the corporation to the corporation that the officer believes has occurred or is likely to occur. This is an expansion over the existing framework under the old Act. That provision essentially applied already to directors, but it expands the concept to officers of the corporation, providing them with a duty to inform as I indicated, in any material violation of law or breach of duty that they become aware of, such officer needs to report that up the chain of command. So that's a fairly important new section that probably is something that oftentimes is done anyway, but it's something that's been revised to make clear that it does apply to officers as well. Next, there's new provisions relating to remote shareholder meetings. Now, as many of you may have been operating under the COVID scenario, the remote shareholder meetings were authorized by Governor Reynolds' proclamations during COVID. But the act has now been revised to include provisions that allow for remote shareholder meetings. Now, many of you may already have provisions in your articles or bylaws with that, but even if you don't at this point, the new provisions allow shareholder meetings to be held remotely as long as each person that's participating can be verified as a shareholder, and as long as the shareholders that are participating have a reasonable opportunity to participate, have input, vote, and so forth. So sometimes it can create some challenges in a virtual environment, especially in terms of voting, and so forth. But the point is that virtual shareholder meetings are allowed, and I would encourage you to use them. We've done a number of them, and they seem to have worked out fairly well for our clients that we've been involved with. So it's something to consider. And just because the governor's proclamation is essentially expired, I believe, in that regard, doesn't mean that you can't still operate even in the non-pandemic world if we ever get there. You can still, in the non-pandemic world, utilize virtual meetings as well. So. Next is changes to forum selection provisions. Not an extensive change, but a new section has been allowed that allows a corporation to require internal corporate claims to be brought exclusively in any specified court, presumably in Iowa, and it also prohibits a corporation from prohibiting any internal corporate claim from being brought within this state or to require such claims to be arbitrated. So this should be a benefit to reduce potential litigation expense, especially in a situation where there could be internal corporate claims or internal corporate litigation or litigation involving internal corporate matters that potentially could be brought either outside the state of Iowa or in a forum that is potentially not convenient for the litigants involved, namely for the bank. And so it basically allows the bank to decide where it can sue or be sued in terms of any litigation involving internal corporate acts. Next, quite a few changes were made to sections involving mergers and acquisitions and share exchanges and so forth. I'll summarize, these are fairly lengthy, but I'll summarize some of the highlights of those. The new act adds a subsection allowing a domestic eligible entity to utilize a plan of merger if their organic law or rules do not provide for procedures for approval of a merger. And this may be important in situations if some of you are operating with bylaws and articles that do not either provide for or do not in detail provide for mergers and share exchanges. This new section allows that to happen. Likewise, a new section was added relating to share exchanges, which allows a domestic eligible entity to use the procedures for a merger if that entity's laws or rules do not provide for share exchanges. And so if no procedures exist in the bylaws for a merger, the entity may use the procedures allowed by Chapter 490 to effectuate the share exchange or the merger as well. Another section has been added allowing the articles of incorporation to expressly limit or eliminate separate voting rights or which create separate voting groups for any classes of security or interest that is to be converted under a plan of merger, and each class or series of shares included in an exchange. So that should make it a little bit more clear in that area. Another section has also been added which allows a plan of merger or share exchange to be effective without shareholder approval under certain requirements that would avoid the need for shareholder approval if each outstanding share of each class or series of shares that an officer is offering to buy, if the shareholders owning such shares will receive in return the same amount and like kind of shares. So some limitations there on shareholder voting as well. Another section has also been added regarding provisions relating to interest holder liability created during a merger or share exchange that is created during a domestication or conversion. So. Again, those are just some kind of a quick summary of the changes to the provisions relating to mergers. There are significantly more than that. And again, like with everything, if you have questions, we invite you to follow up and ask us. Moving on, the new act also provides in a fairly significant change, I think, provisions relating to the retroactive validation of defective actions. So this may mean that this would come about in a situation, say, where the corporation realizes after the fact that maybe it hadn't properly followed its own rules, properly validated an action with proper documentation, either through a shareholder vote or say there was a minutes, corporate consents, and the like that did not properly reflect the transactions that occurred. This allows a corporation to retroactively validate those. A new provision has been added that creates a new statutory section for these defective actions, which section provides that defective corporate actions are not void or even voidable if ratified or validated, and the absence of ratification or validation by itself does not create a presumption that an act was a defective corporate action. Another section defines the process through which a defective corporate action may be ratified. It's not very extensive. and fairly easy to do. And another section also provides the requirements for shareholder approval for any ratification of a previous defective action. If the defective action is effectively ratified, the action becomes valid, effective on the date of the original date of the defective action, which is an important consideration. So let's say you engaged in a transaction that wasn't effectively or appropriately documented 2 years ago or a year ago. If you follow the process in the new act for retroactively validating such action, it is effective not at the time that you complete the validation. It becomes effective retroactively at the time that the original action was taken, even though at that time it was not properly documented. So, another important provision is that provides that each shareholder, regardless of their voting power, is to be given notice of any action to be taken to ratify a defective corporate action. So it does have to go out to shareholders, all shareholders, regardless of their voting power. Finally, another provision regarding ratification of defective actions is a provision that provides that if a defective corporate action that is ratified would have required a filing, then regardless of whether a filing was made in lieu of such filing, the corporation must file articles of validation for the action. So there is a filing requirement to be made with that. Next, there was some. Next, one of the I think larger changes is to some provisions regarding the judicial review of elections and shareholder votes. This is a fairly significant provision that's been added. It's Iowa Code Section 490.749, which creates a new subchapter, an entire new subchapter that grants a corporation, record shareholder, director, or an officer the ability to apply to have the district court of the county where the corporation's principal office is registered to have that court determine the results or validity of a corporate action for or against a director or officer and the result of the validity of any vote by the shareholders. In other words, any specific persons delineated in the new act may petition the district court to rule on whether or not a vote or action is valid and vote or not on whether a officer or director has been appointed correctly, so forth. So important provision there, something to keep in mind. Another provision that has been added is what we call a community interest provision. Many of you may be already familiar with that, but maybe not. I'm not sure. The articles include, the new act includes a community interest provision that allows directors to consider the interests of the community, which are other than shareholders' interests, when evaluating a proposed business combination, merger, share exchange, tender offer, and the like. The significance of this is that that's a broader area of consideration than just determining what is necessarily best for shareholders. It allows directors to take into consideration the overall interest of the communities in which the bank is a part of and in which the bank serves in terms of evaluating a course of action in terms of a merger, acquisition, share exchange, et cetera. We often recommend putting that in bylaws, articles and bylaws, and oftentimes when we're drafting those, we recommend a community interest provision, and we certainly have a sort of one that we use from time to time that has now been codified in the new act to allow that to happen, regardless of whether it's in articles or bylaws. I still think it's a good idea to have it in your organizational documents. Just gives broader authority for directors to kind of consider all constituencies when evaluating a big transaction. Getting short on time here, but I thought I'd mention one thing that's not on the slide. There's also quite an extensive revision to the provisions regarding appraisal rights in the new act. One of the ones that I would note is there's a new provision that removes the requirement that a shareholder must be entitled to vote on a merger for them to have appraisal rights. And to me, this suggests that the legislative intent is that a shareholder not necessarily be entitled to vote, and holders of non-voting shares are allowed appraisal rights as if they held voting shares. So this may sort of expand the idea of appraisal rights beyond those with just voting rights to even shareholders without voting rights. So again, the changes are fairly substantial. It's the first revision in 30 years to the to Iowa Code Chapter 490. A lot of stuff there. I tried to hit the highlights. With the limited time, it's impossible to get into all the details and all the changes, but I would certainly be happy to answer any questions that anybody has on anything that I've said or any sections that you're aware of that have changed that I didn't cover. So very happy to do that. My contact information is on the slides. I'm going to turn it over to Jeff Baxter and Ben Bruner, who are going to very capably discuss loans, documentations, modifications, workouts, and non-judicial alternatives. So without further ado, here is Ben and Jeff.
Good afternoon. My name is Jeff Baxter. I am a partner at the Dickinson Law Firm, as the rest of my partners are here. I practice primarily in the real estate, corporate, and banking departments within the firm. I'm here to talk to you today about documentation essentials. These are not going to be brand new ideas to you. You should not find anything here to be surprising. We're basically just going to be going back to the basics. Most of the time in loan documentation, the basics are the key issues, and a number of the things that I'm going to be talking about here are going to be very important. You're going to want to make sure that you maintain these pieces of information in your documentation in order to effectively ensure the enforceability and the applicability of your documents. So with that, we will get started. First thing that you're going to want to make sure that you do in any documentation that you have is ensure that you have the proper parties. That's going to include both individuals, or if they are entities, if it's a trust, you're going to want to make sure that you have the correct individuals identified. That can be from an individual standpoint. That would include making sure that the names of the individuals are accurate. For instance, you'll want first, middle, last. In my case, it would be Jeffrey G. Baxter or Jeffrey Garth Baxter. If I am a married individual, you want to make sure that my spouse is included in documentation, where you're going to need to have the spouse signed on in the case of homestead issues or things like that. If it's an entity, you're going to want to make sure that the proper entity name is included. That can also include things like DBA. If the business operates under a specific name, ABC Plumbing, for instance, you want to make, but the company is actually XYZ Inc., you want to make sure that your loan documentation is with XYZ Inc. as opposed to ABC Plumbing. Can also include the preferred abbreviation of the entity document, or the entity type. For instance, in an LLC situation, that could be denoted as L period C period. It could be LLC with no spaces or punctuation marks. You just want to make sure that all that information is correct to ensure that your information is accurate. Similarly, if you have a trust that is a party to a document, you want to make sure that you have all of the necessary trustees as parties to the document and signing on. Another item that you want to make sure that you include in all of your documentation and don't underlook is signatures. The first and the most important being that you actually get signatures. I can tell you a number of occasions where we have documents that have been unsigned. Anytime you have a loan closing, as all of you know, you will have dozens of documents potentially that need to be executed, and making sure that you get signatures on all of those is important. And then getting also the correct party to sign in the case of entities or trusts or other things of that nature, where you have particular parties that may or may not be the ones that you're intending to have sign on. Similarly, you need to make sure that documents that are going to be recorded are notarized. You need to make sure that your notarization blocks have all of the requisite information that's required under Iowa law. Legal descriptions, for instance, also need to be accurately described. You'll want to make sure that they are full legal descriptions and not just the cut and paste from the assessor's sites that have more shorthand descriptions of the property. You want to make sure that the legal descriptions are adequately described. If you have personal property that's going to be part of the collateral for your loan, you're going to want to make sure that the personal property is described with enough sufficiency in order to identify it. And you'll also want to make sure that all of your agreements throughout your loan package match, that the defined terms within all of those documents have similar meanings, that you aren't using different meanings or different defined terms throughout all of those documents. For instance, a defined term like collateral that you would be using throughout various documents, you want to make sure that those terms match one another and that they are that they fit together and that they don't contradict one another throughout your documents. Next provision that we're going to talk about, and we'll just kind of go through this briefly, are homestead provisions. Now, these are not going to be applicable against corporations or against LLCs or other entity types like that. They'll be applicable in situations where you have individuals as the borrowers, which in the case of commercial loans might not be that prevalent. In the case of residential loans will be primarily who the parties will be individuals primarily in residential loans. In agricultural loans, you may see individuals, you may not see individuals. So these provisions and ensuring that you have the correct statutorily required information in your loan documents is going to be important to make sure that that your information or that your loans are going to be enforceable. Under Iowa code, homestead exemptions have to include, in order to qualify for a homestead, the property that is subject to the homestead has to have a number of different, it has to meet a number of different requirements. One, it has to include a house that's used as a home by the owner. It can't be just raw ground. It can't be a commercial property. So here it has to be used as a home. If it's more than one, if the owner has more than one property which could qualify for homestead, the owner can select which one receives the homestead and file a declaration of that. The homestead property can't be more than 40 acres in agricultural property, or if it's within a city plat, it can't be more than a half an acre. If the property does exceed that size, the owner can create what's called a homestead plat and designate which part of the property is going to serve as the homestead. There is a case from a few years ago where the owner created a unique property for the homestead plat where they had, I believe it was a 1 acre parcel of ground, and they described a 1 foot border around the edge of the property and then included the driveway and the actual improvements as their homestead plat. And the court ruled that there's no requirement under Iowa law that they designate anything more than what they want. And so there are ways that they can be tricky, that owners can be tricky to try to establish what the homestead plat is. So make sure that you keep aware of that and keep track of that in your documentation. There is also a valuation element to the homestead. It's a $500 valuation, so I imagine you're not going to be able to find very many properties that are a half acre within a city or 40 acres in agricultural ground that are valued at less than $500, but there is that requirement as well. Now, homestead properties are going to be exempt from judicial sale where there's no special declaration or statute to the contrary, but there are going to be a number of different exceptions to that. In the terms of agricultural property, on the slide that we have here, this is only going to apply to agricultural property that's greater than 40 acres. As you can see, there are specific requirements there, and there's specific language that must be included on any documentation in order to qualify. We're not going to get into that, but make sure that your loan documents have this information if it's applicable. In the term of homesteads, if there are spouses that are involved, there are a number of requirements. If the owner's married, the spouse has to sign on. If the spouse fails to sign on, it could jeopardize the collateral. There have been some changes over the last couple of years in Iowa code that do make new exceptions to that, where a court that determines that invalidating the conveyance would unjustly enrich the non-signing spouse. So there are protections for lenders out there, but from a practice standpoint, knowing if your borrower is married and getting a representation from them is important. A couple of other things that we want to include in our loan documents, or at least think about including in your loan documents, are going to be purchase money. If the loan is purchase money, you will get some extra protection against pre-existing judgments of the borrower, but you have to contain a recital that it is a purchase money loan within your loan documents. If you fail to do that, you don't get that protection. So if your loan is purchase money, make sure that you include a recital in your loan documents. There's no magic language under the statute, just that the loan is purchase money. So you'll want to make sure that you include that. Also, if your loan involves collateral that includes personal property, you're going to want to make sure that a security agreement is included as part of your loan documentation. It doesn't have to be necessarily a standalone document. You can have basically a recitation to that within your loan documents, your existing loan documents, but without the recitation to a security document, you will not be able to attach the collateral to your security interest. We have some sample language here in the forms that shows language that you can use as an insert to existing documentation. Next, an item that you're going to want to make sure that you include is the right to inspect financial documents, to inspect the books and records of your borrower. If you don't have those rights, you don't necessarily have the ability to do that if the borrower is not cooperative. So you want to make sure that you include those rights within your loan documentation. Ben will likely talk a little bit more about that in his presentation. Here is some sample language that you can include within your loan documents in order to facilitate that. We suggest that you do get that document or do get this information included because, frankly, being able to review the financial strength of your borrower during the term of the loan is going to become essential, especially in situations like we're looking at now under the pandemic, where there are drastic changes to the borrower and to their business. Having the ability to go through their financials periodically can help protect you and help potentially save your loan. Finally, the last item that we're going to recommend to you that you include in your loan documentation is the right to inspect collateral. Without this right, again, one of the biggest problems that you're going to run into is, especially if you have a collateral that could be decreasing in terms of inventory or livestock or something, or grain, would be the degradation or the removal of those of that collateral from your borrower. If you don't have the right to go on site and inspect their property or inspect your collateral property over the life of the loan, you could find out if you needed to foreclose and take that property back as collateral that it's no longer there. So having that right is also very important. And then I misspoke. There was one more item that we were going to address, and that's the right to appoint a receiver. Ben will probably talk a little bit more about this in his presentation again, but the ability to appoint the receiver is important. You want to make sure that you have someone who can step in and can take control of that property, that business, that collateral, to protect it and make sure that it's available for you in the event that you need to foreclose and you need to get that collateral back as part of a default under the loan. Now I'm going to turn it over to Ben Bruner, who's going to talk a little bit more about loan modifications, workouts, and non-judicial alternatives.
Okay, we should be good now.
Yep.
You want to count me down, or we good to go? All right. All right, again, good afternoon, guys. I'm Ben Bruner, banking attorney with the Dickinson Law Firm. Again, my practice is primarily focused on secured financing, both on the front end, as Jeff was kind of talking about, loan documentation, loan structuring, et cetera. And then inevitably on the back end, as far as workouts, forbearance, modifications, et cetera. you guys are in the business of making loans, and inevitably you're going to have some bad or delinquent loans. We like to flowerily call them stress credits. So it's important at this point, though, to number one, identify the issues. Get into a file, you have a stress credit, identify any issues, look at the options that are available, and then truly develop a plan. And hopefully this information will kind of help you go through those 3 steps of kind of dissecting a troubled loan. So let's get into it. I know we don't have a whole lot of time here, but analyzing a loan file. So this kind of partners with Jeff's earlier presentation. So the first step before considering any loan modification, workout, forbearance, or the like, you or your legal counsel should look at a file, analyze the loan documents to make sure you don't have any inconsistencies, missing information, or other potential enforceability issues. Again, Jeff touched on a number of the basics as far as loan documentation, and I'll touch on some of the basics, I guess, on the back end here. Proper parties and signatures. Obviously, you want to confirm that the proper parties are named and have signed the appropriate documentation. Proper notarization. So defective notaries are another item. Become a major issue, because even a minor defect can allow maybe a bankruptcy trustee to try to avoid that mortgage via their strong arm authority. Legal description errors. Again, if an error in the legal description is discovered, it's much easier dealt with via mutually agreeable amendment as compared to trying to reform that in any subsequent litigation. Default notices. So commercial loans, you'll need to see what's in the loan documentation, and ultimately the contractual requirements for notice will need to be complied with. Agricultural properties, ultimately you'll need to deal with a 45-day notice and right to cure. That runs and kind of coincides with that 45-day mandatory mediation period. Inconsistencies between the note and mortgage. So you will want to verify that the mortgage terms clearly secure the particular indebtedness. This is important, especially when you're dealing with replacement or alternative notes. Loan history. Make sure you have a firm grasp on the history, accounting of payments, interest rates, etc. And then lender liability claims. So you need to examine any potential lender liability claims, and they typically come in the form of a promise to lend additional funds or a promise not to foreclose. So get with your loan officers, go over the file, ultimately look and see what promises may or may not have been made, either orally, written, etc., because those can become a huge issue. Collateral value concerns. So you should obviously analyze the value of the collateral in relation to the outstanding debt. Whether the loan is upside down or if there's equity in the property, that'll have a direct bearing on whether you essentially want to pursue guarantors or need to pursue guarantors, want a deficiency judgment, etc. And similarly, as Jeff noted, you want to look at the financial condition of the borrower and the guarantors, as again, that may dictate the form of workout that you end up pursuing. So moving on to kind of our first non-judicial option here. So loan and mortgage modifications. So oftentimes, the first request from a stressed borrower is for a simple modification of the loan. They want more favorable repayment terms. And this can be beneficial, certainly. Borrowers are dealing with kind of ever-changing markets and an unpredictable economy. And if there is an opportunity for adjustment, ultimately that may provide a best opportunity for a lender to get repaid in full in the long term. But formal modification of mortgages is essentially required in 2 scenarios, where there's an extension of the maturity date and where there's an increase in the secured obligation. Extension of maturity date, that goes to some statute of limitations as far as mortgages under the Iowa Code. Mortgages are enforceable for 10 years beyond the maturity date if the maturity date is set out in the mortgage. They're enforceable for 20 years if the mortgage does not include the maturity date. So again, that's important to know if you modify your maturity date there. And then again, if you extend or increase the credit amount, in order to take advantage of the future advances priority that's provided in the Iowa Code, ultimately you need to amend the mortgage to reflect that increased amount. If you're not familiar with that language does need to be included in the mortgage. So again, reach out to us if you have any issues or you're unfamiliar and need that information. I'll touch briefly on some potential priority issues that loan modifications can, I apologize, I didn't switch over here. Loan modifications can present. Courts essentially say, senior lenders will not lose priority except to the extent that the modifications materially are prejudicial to the junior lien holders. And this is a case-by-case basis, but generally you can assume that if you increase the interest rate, increase the amount of the debt, or reduce the repayment period, those would be deemed prejudicial, and you might have a priority issue as it relates to junior liens. Alternatively, if you reduce the interest rate, reduce the amount of the loan, the secured obligation, or extend the repayment period, you're probably not going to run into any issues as far as priority there. Make sure in your mortgages, ultimately, that you expressly provide for the right to amend and modify the mortgages. That can help to overcome any priority issue. And I have some specific language that I include in my mortgage forms that aren't in a whole lot of bank form mortgages. So again, feel free to reach out to us if you'd like that language or would like us to review your forms. And then guarantor consent. So guarantor consent to loan amendments technically isn't necessary in most scenarios because guarantees are typically continuing in nature and cover extensions or modifications. However, courts can say in certain scenarios that the modification creates a fundamentally different risk to the guarantor and can ultimately avoid that guarantee. So we always say it's good practice to get the guarantor's consent to any modification, regardless of the terms of the guarantee and regardless of the nature of the modification. So another tool or workout option is a forbearance agreement. And the basic concept is the lender agrees to forbear exercising its remedies, provided that the borrower ultimately does no further defaults and takes certain steps to correct the issue. They need to address their payment defaults or their collateral concerns, etc. I will say it's typically a strong indication that the credit is probably limited, at least in its current form. But again, it does provide an opportunity for the borrower to ultimately implement a workout strategy. I'll also say that in my experience, a lot of times these forbearance agreements are pretty heavily negotiated over the course of weeks or even months, and a lot of times not signed. We typically recommend that, if you are going to enter into negotiations for forbearance, not a bad idea to kick out notices, requisite notices, and then maybe even file the formal action, because that can always be dismissed if you reach agreement with the borrowers. But if negotiations fail, you won't lose a whole bunch of time. And ultimately, I will then kind of touch on some key and recommended provisions for forbearance agreements. So you should obviously insist that the borrower expressly acknowledge the validity of the loan documents, as you don't want to fight about that in litigation down the road. Should litigation commence, you don't want to argue also over the existence of the default, so you should get the borrower to expressly acknowledge the nature of the default and acknowledge that all notices were given and or waived. The amount of debt should obviously be included, and the borrower should acknowledge that being the correct amount, because again, if litigation is commenced at some point in the future, that's not something you want to truly fight about. And then one of the key kind of benefits and critical components of forbearance agreements is the lender obtains or should obtain the borrower's waiver of any and all claims against the lender. And it kind of poses a critical question for the borrower. If they believe they have legitimate claims against the lender, signing the forbearance agreement essentially waives that or cuts those claims off in return for the extension of additional time. Forbearance period, so the lender generally grants borrower a specific amount of time to implement their strategy. That could be 30 days, 60 days, 6 months. It just depends on the type of situation you're dealing with. And then there's some additional suggested provisions that I also noted in here. Forbearance fee, this usually covers your out-of-pocket costs associated with the forbearance. They're usually caused by your damn attorneys and title work, etc. Bankruptcy provision. So a covenant not to file for bankruptcy is unenforceable as against public policy. However, I typically include a provision that makes it clear that the forbearance agreement is effectively void in the event of a bankruptcy and if any payments are set aside. Borrower's covenants. So you want to capture the borrower's promises to essentially execute their workout strategy. So that's a promise to either list collateral, provide certain documentation, as Jeff alluded to, pay off other claims against the collateral, etc. And then remedies, you just want to make sure you're clear that you have the right to essentially move forward and exercise any and all remedies if there's a default under the forbearance agreement. Some unique remedies, sometimes we have what we call a confession of judgment be placed in escrow. that can then be filed with the court upon a default under a forbearance agreement. So again, these situations are all unique and no one form fits all. So feel free to reach out to us. We'd be happy to discuss and walk through the situation. Okay, short sales. So short sales are fairly straightforward, at least as it relates to lenders. Essentially, you agree to take a reduced price to release a mortgage on a piece of property. Short sales, you can still couple that with a debt settlement agreement if you want to retain a deficiency against the borrower. That does need to be a separate agreement, and we'd recommend some of the same provisions that I just mentioned in the forbearance agreement. You could also essentially retain a deficiency note, which is typically unsecured, to kind of acknowledge that deficiency if you truly want to try and retain it and the parties are agreeable. Voluntary non-judicial foreclosure. So unlike traditional judicial foreclosure, the primary benefit here is that it removes junior lien holders and obtains a marketable title within 30 days. The only drawback is lenders do have to waive their right to a deficiency against the borrower under this procedure. So if you do need a deficiency, then you need to look towards a deed in lieu as the preferred process. Again, there's going to be a written agreement that's required here that you'll want to include some of the same provisions as we discussed earlier. Structurally, the structural requirements for a voluntary non-judicial, you need a jointly executed agreement that gets filed with the county, attesting to the fact that the parties have entered into non-judicial foreclosure. There's a disclosure and notice of cancellation that the borrower needs to get, in which they have about 5 days to cancel the agreement. That needs to be a part of the agreement. And if they cancel within that 5 days, ultimately, that agreement is terminated. If they do not, the foreclosure becomes final, subject only to redemption of junior lien holders. So you get the jointly executed agreement, you get a deed from the borrower at the same time, usually a special warranty deed. And despite filing those two documents, again, the foreclosure is not final until you give notice to junior lien holders that they have 30 days to redeem. And if they do not redeem, again, their liens are wiped out. You have the property free and clear, and you're kind of an expedited property owner at that point. And then just finally, I'm going to touch briefly, I know I'm running out of time here, deed in lieu of foreclosure. So the deed in lieu of foreclosure allows the lender to obtain immediate title, again, without judicial action. It does not remove junior liens or encumbrances. So again, if there are junior liens out there, once you do the title work, you need to go the non-judicial foreclosure process. No requirements of notice of default or right to cure, or any mediation requirements prior to accepting a deed in lieu. And you can reserve a deficiency if you set it out in a separate agreement. And then my last slide, there's just some language that needs to be included in each deed in lieu to address any equitable mortgage claim. That's noted in the slide. And then to avoid a fraudulent conveyance claim, there's additional language provided there as well. So this was kind of a quick and dirty rundown of some options, but we'd be happy to help you out examining a file, developing a plan, and then implementing that to avoid, hopefully, litigation. And if there's any questions, certainly let us know. Rachel for a case law update, I believe.
everyone. My name is Rachel Soderstrom. I'm an associate attorney here at the Dickinson Law Firm. And I will be presenting today on cases that have come out from both the 8th Circuit and the Iowa appellate courts within the last year since our previous banking law seminar last year. I'm going to go a little out of order on my slides here, so try not to be too distracted by that. But the first case that I'm going to talk about is AgriFund LLC versus Heartland Co-op. This case involved two financing companies and whether one of the financing companies was a holder in due course. So Heartland is a cooperative that sells and provides financing to farmers through the Heartland Credit Company LLC. AgriFund is also a financing company that provides financing to farmers. AgriFund and certain farmers signed an agricultural security agreement that provided AgriFund with a lien over all of the farmers' crops and assets for the 2017 year. AgriFund perfected that lien by filing a financing statement directly after the note was signed. Heartland, around the same time, also provided a financing to the same farmers in the amount of $150,000, which was later increased to $500,000. Heartland also perfected its security interest by filing a financing statement. Shortly after the execution of the AgriFund note, AgriFund sent notice to Heartland disclosing its lien over the farmers' assets and stating that the proceeds of the farmers' crops should be sent to AgriFund. AgriFund and Heartland then entered into a subordination agreement in which Heartland agreed to subordinate its loan to AgriFund, which gave AgriFund first priority to collect the farmers' assets up to $4,410,780. And then on November 12th, 21st, 2017, the farmers opened account at Heartland, the financing company that has the junior loan to AgriFund, had an open balance of $328,124. On that date, the farmers gave Heartland a check to pay off the full balance in their open account. However, the check that was used was derived from proceeds of the farmers' sale of the crops to a different purchaser that AgriFund was unaware of. Thereafter, AgriFund sued Heartland, alleging conversion and seeking remittance on the farmers' assets that were transferred to Heartland. The issue for the court was whether Heartland was a holder in due course under these facts, and in particular, whether Heartland abided by reasonable commercial standards of fair dealing. The court determined that Heartland did not qualify as a holder in due course. The court reasoned that because Heartland was aware, through the subordination agreement of AgriFund's superior lien, Heartland should have taken steps to confirm, either through the farmers or through AgriFund, that AgriFund had been fully satisfied before accepting the payment. So the takeaway from that case is if you know you are junior to a superior loan, always ensure that the superior lien has been satisfied before accepting the payment. The next case I'm going to discuss is Wells Fargo Bank versus Windows USA LLC. So this lawsuit stems from a customer financing agreement between Windows USA and Wells Fargo. Windows USA sells exterior home remodeling and installs them as well. On November 11, 2011, Windows and Wells Fargo entered into a general dealer agreement where Wells Fargo would provide Windows USA customers with financing to purchase home improvement products through the Wells Fargo Home Projects program. The purpose was to provide Windows USA customers with greater access to credit to purchase its products. If Wells Fargo agreed to provide the financing for a Windows USA customer, Wells Fargo would pay to Windows the amount invoiced to the customer less the applicable discount rate, which was the term used within the contract. And then additionally, shortly after that agreement was into place, Windows USA and Wells Fargo entered into an amendment wherein USA agreed to provide Wells Fargo with a right of first refusal and promised that it would not participate in any consumer financing programs or unique credit term plans other than Wells Fargo's Home Projects Plan, unless it first submitted the credit application to Wells Fargo and Wells Fargo denied the application. In the lawsuit, Wells Fargo alleged that Windows USA failed to honor its right of first refusal by submitting financial applications to competing customer credit companies in violation of their agreement. It was alleged that the president and CEO of Windows USA admitted to Wells Fargo that Windows USA had been offering its customers consumer financing options to competing businesses, and that they had been doing so since December of 2011, which was shortly after the First Amendment was signed. On the other side, Windows USA alleged that Wells Fargo was using its superior position under the agreement to unjustly enrich itself at the home improvement company's expense. Windows alleged that Wells Fargo drastically increased the discount rate included in the contract and changed its financing and obliquely enhanced the credit standards for customer applications to increase the bank's profit margin and avoid paying USA certain growth rebates and volume bonuses. Both parties moved to dismiss each other's claims, and the issues before the court were whether there was sufficient consideration for the First Amendment and whether a tortious interference with prospective business advantage claim is an actionable claim when the conduct of which the tort is founded arises from an agreement and not a tort. So the outcome in this, the court decided that there was sufficient consideration with that amendment because there were several different changes from the first agreement to the amended agreement. Although the consideration was not necessarily dollar figures, the court noted that Wells Fargo gave up its right to terminate the agreement upon written notice at any time, agreed to provide at least 30 days written notice prior to the end of the contract, and it gave up its right to unilaterally terminate the agreement without notice. So the Windows claim was dismissed on that ground. And then the second claim was that Windows USA, their tortious interference with prospective business advantage claim was not actionable. The court noted that Iowa law recognizes that torts can be committed by parties to a contract. However, the test is whether the test hinges on the source of the duty. So if the duty is implied by law, like you need to go 55 miles an hour, that is something that could give rise to a tort. However, if the duty is only from the contract, a tort cannot be brought. It must be a breach of contract action. I'm going to try to go quickly through this one more case before we let you guys have a quick break. The last one I'm going to talk about today is PSFS 3 Corp. versus Seidman. So in this case, this case involved financing agreements as well, and in the years of 2005 and 2008 or 2009, the NCMIC Finance Corporation and hundreds of optometrists, dentists, and their professional entities entered into finance agreements related to the purchase of certain sound systems that they would have in their waiting rooms. The finance agreements contained normal common clauses of like hell or high water clauses, a floating form selection clause, and a default provision authorizing acceleration of all future payments. The vendor of the sound systems allegedly sold the systems by telling purchasers that that there would be enough advertising on the systems to cover the financing payments, and that they would not need to provide any payments for the sound systems because advertising would cover it. However, when the advertising payments stopped and the vendor refused to pay for the financing agreements installments that they had allegedly agreed to, the dentist and the optometrist stopped making payments, and NCMIC filed suit against them. And this suit stemmed into a multi-district litigation suit where the multi-district litigation panel of the federal courts transferred the case to Florida, and so the Iowa cases were put on a hold until the Florida cases were determined, and then the court in Iowa could determine liability and damages for each of the defendants that NCMIC had sued. However, shortly after NCMIC signed or brought forward these allegations, they assigned all of their financing agreement rights to a different company called PSFS3. PSFS3 was a new formed, wholly owned subsidiary of the company. The assignment allowed PSFS3 to invoke a floating forum selection clause so that all of the defendants could be under the jurisdiction of the Iowa court. After the conclusion of the federal court litigation, it was a favorable outcome for the NCMIC and PCFS3, and the court lifted the stay to enforce it under Iowa law. Now, when Iowa courts came to enforce the agreements, one of the fighting issues between the parties was whether the assignment of the financing agreements to from NCMIC to PSFS3 was a sham transaction only used for the purposes of obtaining personal jurisdiction in Iowa. The second fighting issue was whether the financing agreements were even valid under Iowa Code Chapter 535 because they did not disclose a material term such as the interest rate, and the interest rate charged was outrageous. The outcome of the court determined that the assignment was not a sham, but rather a transparent transaction with the limited purpose of creating an optimal enforcement mechanism with respect to the financing agreements. The court noted that because there is an express language within the contract, within the financing agreement, that allowed for assignment to anyone, the literal enforcement of the contract terms was fair. And so that outcome was favorable to PSFS3. The court also determined that the financing statements were valid under Iowa Code 535. In doing so, the court noted that the payment over time and the amount of each payment is sufficient disclosure of the material terms under the code. Because the financing agreement did contain the number of payments over time and the amount of each payment, they determined that it was sufficient. They also noted that under Iowa Code Chapter 535 that a person borrowing money for a business purpose is permitted in writing to agree to the rate of interest of a credit transaction. Given that the defendants had in writing agreed to this, there was no violation. The takeaway from this case is that a floating forum selection clause is enforceable in an assignment to a wholly owned subsidiary, even if solely for the purpose to monitor the payments where necessary and enforcing them, is not a reason to invalidate the express contractual language. Additionally, as long as the number of payments over time and the amount of each payment is included, there is sufficient disclosure of material terms related to interest under the contract. I think I'm a little over my time, but I'll give you guys a quick break. When we come back, Amy and David Rep will be presenting on data processing, agreement considerations, and taxation issues.
Welcome back. I'm Amy Plummer. I am going to talk along with David Repp today about a few factors to think about with bank mergers and acquisitions. Specifically, I'm going to talk about data processing agreements. So data processing agreements are vendor agreements with companies such as Fiserv, Jack Henry, Shazam, FIS, to name a few. These are your online banking platforms for loans and deposits, mobile banking, your online systems. I'm sure many of you bankers out there are more than familiar with these systems. Generally speaking, these type of agreements are very lengthy and complex, easily 50 to 100 pages long. Typically, the way they're structured is there's a master services agreement that describes the legal terminology relating to the contract in and of itself, along with certain schedules that actually describe the software that's being purchased. They're written often in favor of vendor, meaning your opportunity to negotiate is somewhat limited, but there are a few things we're going to talk about today that you might want to think about, particularly if there's a future sale of your bank in the future. One thing to think about essentially is term and termination. Salespeople for these data processing companies will often sell you the software at a better rate if you agree to a longer term contract. We've seen contracts as long as 5 to 10 years, but essentially your best option if a future sale of your bank is contemplated would be to keep it shorter. The reason for that is you are likely going to be obligated to pay early termination fees if you do decide to sell the bank down the road prior to the end of the term. Another thing we suggest that you keep an eye out for are auto renewal clauses. These are clauses that provide that the agreement will automatically renew for another year, usually at the data processing company's then current rates, unless you let them know that you do not intend to renew within a certain period of time, such as 180 days. When we help banks negotiate these agreements, we try to strike those all together with the thinking that the software company should work directly with you to negotiate any future renewal terms. If nothing else, we should ask that they give you notice of what the rates in effect at that time will be, so you know what you're going to be getting into at that renewal time. We talked a little bit about if you terminate voluntarily because you're going to sell your bank, but there should also be a clause in there that if the data processing company does not perform its obligations, whether the service is not being provided as promised, or it shuts down for a certain period of time, if things go wrong, you should be able to terminate early without paying penalties, such as the early termination fees that we're going to talk about in a minute. Another thing that really kind of comes up often when we work with banks who are looking to sell is the inconsistent maturity dates in the schedules. So mentioned earlier that there's kind of a master agreement that describes the legal terms of the agreement, but then there's schedules that go through each particular software system that you're purchasing. Ideally, what we like to see is that the termination dates of each of the software types of software platforms that are being purchased end at the same time. That certainly makes it a lot easier if you're looking in the future to determine what you may need to pay for early termination. However, if you're not careful, sometimes those termination dates can vary depending on the software that you purchase, and as you would imagine, leads to a bit of a nightmare when you, or if you need to terminate early due to a sale. Talking a little bit more specifically about early termination fees, the way these agreements are usually written is if you sell your bank, whether you sell all of the stock of the bank via change of control, or you sell substantially all of the assets, you're going to need to pay the life of the contract through the end of the term. They usually apply a percentage, such as 80% of the then remaining fees. So that's something to keep in mind. One thing that sometimes we can negotiate if we do so up front, meaning prior to signing the agreement with the data processing company, is to negotiate a lower termination fee percentage if you terminate later on in the term. So meaning If you had signed a 5-year data processing agreement and you need to terminate in year 4 because you're selling your bank, they may agree to lower that percentage from 80% of fees for the then remaining term to 70 or 60%. Again, that's something you should think about doing, though, when you sign the original data processing agreement. One thing we always warn customers, banks to keep in mind relates to the credits that you're promised when you sign these agreements. They're sometimes called flex credits, or essentially they're a discount that the software companies will provide to you if you, maybe sign a little bit longer term agreement. They will issue what they call flex credits, where you are provided, say, $10,000 off the fees that you would pay. But the trick is that these past credits become due back to the data processing company if you terminate early. So a lot of times if banks go to sell and they're trying to determine what sort of fees they owe to the data processing company, they may forget about the fact that they were given, a $10,000 or $20,000 flex credit to enter into the agreement to begin with, which they're then obligated to pay back. There may be an opportunity to negotiate the obligation to repay those flex credits upon sale if you think to do so ahead of time. Lastly, relating to termination fees, what we like the data processing companies to provide is a clear and articulate description of what the costs are. When the banks that we work with are looking to sell, they often ask us to help them calculate what they can expect for the early termination fees. Between the software schedules having different termination dates and the percentages being applied to the then remaining fees, it gets a little complicated. If you work with the data processing company in advance, they'll often put together a chart or a calculation sheet to show an example of what you may owe if you do need to terminate early. That was with respect to early termination fees. I want to talk a little bit about data deconversion and conversion fees. These are the fees that the data processing company is going to make you pay to deconvert your customer data from the seller bank's platform to the buyer bank's platform. Oftentimes, the way this is written within the agreement itself is that upon a notice to deconvert, you're going to have to pay at closing their then current deconversion fees, which are easily in the tens to hundreds of thousands of dollars. Often a surprise to seller when they realize they're looking at these substantial fees when they sell the bank. What you can do, if you do it prior to signing the data processing software agreement, is seek to put a cap on those deconversion fees. They're still going to be high, but shouldn't be quite as, a little bit more easy to understand what you're going to be facing than if they just apply their then current rate. To this day, I'm not sure we've ever quite figured out how they determine what those fees are. It's usually the number that they just provide. Again, avoid standard applicable rates. Those are the words that you want to avoid in your agreement. One other thing you can be thinking about if you're negotiating a data processing agreement is to think about what might happen if you sell your bank to another bank that's on the same platform. So if you're a Fiserv bank using Fiserv services, and you sell to another bank using Fiserv services, they'll often work with you to reduce the early termination fees. We've seen those reduced rates as low as 30% rather than 70% or 80% of the fees for the then remaining term. So again, that's something you want to include early on while you're still negotiating the data processing agreement. They may work with you if it's not already within the document itself, but your success rate is going to be a lot better if you negotiate ahead of time. Same thing applies with deconversion fees, the fees that they're going to charge to deconvert your customer data to the buyer's platform. Sometimes they're even willing to eliminate it altogether, though that's somewhat rare. More likely than not, they'll agree to reduce those deconversion fees if you negotiate it in advance. Last but not least, it's not on my slides, but I did want to point out that if you are thinking of selling your bank or acquiring another bank, one of the first things you need to do is talk to your data processing provider to determine what their schedules are for the deconversion of the data. We're finding banks that would love to have closed a deal at year end, looking to next spring or even early next summer to get on the calendar for the deconversion schedules of these companies. So it's a big factor when it comes to selling your bank and something you should always be thinking about, particularly when you're negotiating your new data processing agreements. So with that, I'm going to hand it over to David Repp, who's going to talk about taxation issues with respect to mergers and acquisitions.
Hi, I'm David Repp. I'm with the Dickinson Law Firm. I'm a tax lawyer. I've been with the law firm for about 30 years. Grew up on a small family farm in Dallas County, got an accounting degree, so I know I love numbers, and this is why I chose this particular area. So I'm going to talk today for about 15 minutes or so on the two best times in a bank owner's life, and that's the time that the bank owner buys a bank and the time that a bank owner sells the bank. Generally, these two individuals, the buyer and the seller, they have irreconcilable differences. So typically you have a buyer that wants certain provisions in their agreement, and you've got sellers that don't want those things in their agreement. So we're going to talk about those and spend some time on them individually. Sellers' desires, I just listed 3 of them here. This is a 30,000 foot level discussion and talk, so we can't get into too much detail. Right, I limited them to 3 basic categories. The seller's desires, they want liquidity, right, because they're selling the bank. They want to have something that they can sell and convert to cash quickly. They want minimal or no taxation, and they want complete absolution for prior sins, meaning any liability that might have accrued in the past. They want to kind of leave that behind them so they can retire to a nice Caribbean island someplace and live the rest of their life without having to worry about any creditors chasing them. Let's talk about each one of these individually in more detail. The seller's liquidity desires are generally just cash, right? Sometimes stock of a publicly traded buyer might have some liquidity issues to it, so that is nice because you can easily convert publicly traded stock of a seller into cash whenever you wanted to. Cash will always trigger taxation, though. So anytime that you're going to receive cash for your stock or for assets in a sale of a bank, you can count on some taxation issues taking place here. Generally, it's capital gains. Sometimes it's not, depending on the situation. So there are ways to minimize the tax consequences of a sale. And probably the easiest way to minimize those tax consequences, because they're going to happen sooner or later, and that is through an installment sale obligation. Right? So the concept there is that if you received all of your sale proceeds in 1 year, you're going to be taxed primarily at the highest income tax rate for individuals. And that could be a lot. For capital gains, that's 23.8%. And for ordinary income, that would be 37%. Typically, bank sales are going to be taxed at the capital gains rate. So we're looking at 23.8% would be the highest rate. You generally get into the highest rate at about $450,000 of adjusted gross income. So you can kind of calculate where you are. But below that, though, you've got a 15% level of taxation and a 20% level of taxation as well, too. So consider installment payments. That's actually one of the few things that actually installment payment might be desirable by the buyer and also by the seller. And we'll talk about the buyer's interest in installment payment later as well, too. And then you want to consider the receipt of a buyer's securities. I mentioned that before. So if you're interested in liquidity, cash is nice. But if you have a buyer that is a publicly traded company, say for instance you've got Wells Fargo coming at you and wanting to buy your branch, well then the stock of Wells Fargo is highly liquid, and you could receive that, and it might qualify for a tax-free exchange. But it's not really tax-free, it's more tax-deferred, right? So you can receive the Wells Fargo stock as consideration for the sale of your branch or your bank, and then later you can decide when you want to sell your Wells Fargo stock. That's when the gain is recognized, which is very nice because you get to choose the timing of when you recognize that capital gain. Generally, though, just to let you know, is that if you want to pursue a tax-free merger, in that instance, that example, then you're going to have some participation with other stockholders of the bank as well, too. Unless you're a stockholder that has 40% or more of the stock of your bank, in which case you could qualify then just on yourself as having a tax-free exchange. So you've got options if you own a lot of stock of your bank. Second, the seller's taxation desires. So generally, you want to defer as much as possible the taxation of the receipt of the proceeds of the sale of your bank. We talked about that just a little bit here. The installment sale obligation is a good way to do that. It kind of minimizes the big tax hit. You're still going to be taxed at it, hopefully just at a lower rate, though. And then also, too, a stock sale is different than an asset sale. Generally, if you are a seller, you want to sell stock. You don't want to sell assets. And the reason is because if you sell assets, you're going to recognize gain at the entity level. And then to get that cash out of the entity itself, the corporation, you're going to have to dividend that out and liquidate it, get the cash out of the corporate shell. That's going to trigger a second level of stock. Now, if you're an S corporation, that's going to mitigate that tax, that double tax hit quite a bit. But you're still going to have more tax if you do an asset sale in an S corporation than if you were to do just a straight stock sale. And then there are other reasons why you might want to do a stock sale as well too, but we're going to talk about that later. And then you might want to consider receiving securities of the buyer bank. We talked about that too in the Wells Fargo example. If you've got either a publicly traded buyer or not, you can still receive securities of that buyer and then not have to recognize gain. But if you're not a publicly traded buyer, then you're going to be beholden to, you're probably going to be a minority shareholder of the buyer corporation. And then you're going to be subject to whatever the majority owners of that buyer corporation decide that they want to do. So you're going to have an illiquid asset if that happens. But it will be tax-free though, or tax deferred. The other consideration you might want to think about is an ESOP plan. So in other words, instead of selling your stock to a buyer bank, you could actually create an ESOP plan, an employee stock ownership plan for the benefit of your employees. And then you can actually sell your stock to that ESOP plan. Now the benefit you have by doing that is, number one, is the beneficiaries are going to be the employees of your banks. It's going to be employee owned. That's kind of nice. But you can also structure these things so it's a sale to an ESOP plan, then an ESOP plan can later sell to a third party. That's possible as well too. The benefit you get as a seller to an ESOP plan is if you meet the threshold requirements, then the sale of your stock to the ESOP plan and the cash that you receive from the ESOP plan is going to be tax deferred, just as if you were to receive publicly traded securities of a buyer, as I mentioned before. So you're not going to have to recognize gain on the receipt of cash from an ESOP plan that you sell to. There are some conditions though. What you have to do is you have to take that cash and you have to invest it in publicly traded securities, any kind of publicly traded securities. And then what you do there then is that when those publicly traded securities are later sold by you or your estate, then tax gets recognized on that. Now, if you hold those publicly traded securities until death, you get a step up in basis, and no one ever pays tax on that. So death is the ultimate tax loophole. Not a very comforting way to avoid taxes, though. Seller's liability desires. This is the third one. A stock sale is preferred to an asset sale. And the reason is because when you are an owner of stock of a bank corporation and you're selling that, you want to sell stock of your corporation rather than the assets because you've got these uncomfortable, unknown liabilities that may be lurking in the past, that may come forward later someday down the road to haunt you. And I'll just give you a quick example that we're all familiar with right now, and that is the Purdue Pharma situation. Are we familiar with Purdue Pharma? Purdue Pharma is the one that promoted all the opioid pain medications, and they got sued in class action suit, and they're working on a settlement right now. So the Sackler family are the owners of Purdue Pharma. Purdue Pharma is a corporation, and the Sackler family is the one that's really kind of going through the bankruptcy here, and they're the ones that have the money on the line here. The reason why the Sackler family, the owners of Purdue Pharma, are involved here is because any kind of a bankruptcy or dissolution of Purdue Pharma would come out to the Sackler family. So the Sackler family would eventually be liable for the debts and obligations of Purdue Pharma to the extent that they received any kind of distribution proceeds from Purdue Pharma. So just because that you sold assets of a corporation and you retained the stock of your corporation, and then that corporation then liquidated and you got all the asset sale proceeds, still later down the road, any of those unknown contingent creditors in your S corporation or C corporation can come after you as the distributing shareholder to the extent of any distributions that were made to you. So if you were to sell your stock to a third party, then the third party has all of those contingent and unknown liabilities, and you just take your cash proceeds as a seller of stock, and you don't have to worry about that at all. However, in most purchase agreements for a stock sale transaction, you're probably going to give some representations and warranties about any unknown creditors, and you're probably going to contractually bind yourself for any of those unknown and contingent liabilities. You're probably not going to get around that. Let's move on now to the buyer's desires, and I've identified 3 general categories for that as well too. First is tax deductibility. So what do we mean by this, tax deductibility? Well, in a tax-free merger or acquisition, where it's tax-free to the seller, generally you get transferred basis, which means that the buyer receives the same basis as the seller, which means that if this buyer were to someday liquidate and sell those assets, they're going to have to recognize gain, just as if the original seller would have recognized gain. So really what you're doing is that in a tax-free merger situation or acquisition situation, from a buyer's perspective, is you're buying the tax liabilities of the seller. That's generally why buyers don't want tax-free mergers. They typically want taxable mergers. Sellers, on the other hand, want tax-free acquisitions and mergers. So there's the dichotomy there. Number 2 is that protection from sellers' liabilities is that asset purchase is preferred to a stock purchase agreement for the reasons that we talked about before, but just in reverse. So when you're a buyer, you want to purchase assets. And the reason why you want to purchase assets is because the corporate stock stays with the sellers. And if they later liquidate those shares of that corporation, the seller corporation, those unknown and contingent liabilities will remain with the selling shareholders, not with the buying shareholders. Clearly an incentive for the buyer to buy assets. Seller indemnification provisions in a purchase agreement, of course, can kind of mitigate those issues, and typically they always do. And these things are always negotiated in these agreements. Typically what happens is that generally most of the time the buyer is the one that wins out on these arguments. So typically we see mostly asset sales rather than stock sales. Let's talk a little bit about the structure of how an acquisition can occur. Forward triangular mergers, we often talk about that, and why do we do a forward triangular merger? Sometimes you've heard of reverse triangular mergers as well too. What that does is that when we acquire a bank from a buyer's perspective, the buyer will typically drop a subsidiary and fund it with a minimal amount of cash. And then that dropped subsidiary will be the acquirer of the stock of the target corporation, so that the target corporation is merged into the subsidiary. What that does is it does a couple of things. Number 1 is that it simplifies the transaction because you're buying stock, first of all. Number 2 is because you've got the subsidiary that's acquiring this bank, is that the buyer's shareholders don't have to approve the transaction, right? The subsidiary acquiring corporation, its only shareholder is the parent corporation. They're the only shareholder that gets to decide this. Management and the board of directors gets to decide those decisions, not the shareholders. A reverse triangular merger is just the opposite. So you'd have you'd have a subsidiary that's dropped by the acquiring corporation. That dropped subsidiary then, instead of acquiring the stock of the target, is that the subsidiary will actually merge into the target corporation, with the target corporation being the survivor. But as a consideration for that transaction is that the parent corporation will issue cash or its own securities to the selling shareholders, such that we end up in the same exact place with a reverse triangular merger, that the acquiring parent corporation will own all the stock of the target corporation. So why would we want to do a reverse triangular merger as opposed to a forward triangular merger? The answer is simple. This is because banks typically have a lot of agreements that need to be assigned to any kind of acquirer. These agreements would have due on merger clause, or it terminates on the instance of a merger or an acquisition, any kind of a transfer to a new entity. So if we don't merge a target corporation into us, if we merge into them, then there's no change in the corporate entity itself. So we don't have to go through and assign all of those contracts, renegotiate them, and all those other uncomfortable and time-consuming tasks and obligations. So reverse triangular mergers are pretty common in the industry. They have a lot of advantages for the reasons I just mentioned. The buyer's payment desires. We talked about one of the things that is common with regard to a buyer and a seller, and that's payment over a period of time. So you think about this, you negotiate a purchase price. Instead of paying all that purchase price in 1 year at one time, is that maybe you spread that out over a period of 5 years. That has double benefits for both the buyer and the seller. For the seller, they get to report those proceeds on the installment basis. A little bit each year, they minimize all their taxation requirements and all that high income tax they have to pay. And then from the buyer's perspective, they don't have to, it's basically seller financing, so they don't have to go out and acquire any financing for the purchase of it. So the seller is actually helping to finance that. So they can be double benefits for both buyer and the seller. And then using the buyer's securities as consideration can be nice sometimes, right? Because if you are a buyer, you have to either go get the cash, use up your own cash, borrow it, somehow raise the funds to acquire a target. But if you can use your own stock as consideration for an acquisition of a target, it's a cashless transaction, and so you can do the transaction and don't ever have to figure out any way to raise the money to do so, right? You've got more shareholders, of course, as a result, and you've got some dilutive effect as a result of that, but it's a cashless transaction. Sometimes that's desirable. And last, stock purchase versus asset purchase. We talked a little bit about the distinction between that. An asset purchase can be much more complex because you are selling each individual asset to the buyer. In a stock sale, it's pretty easy. All you do is you just assign the stock to the buyer. But an asset purchase, you got to go through and transfer each individual asset, including the pencils and the stapler and everything. All that's included. The stock purchase agreement, of course, is less complex. Buyer's requirements usually have warranties and representations when you do a stock purchase agreement. So you're not going to really, as a seller, you're not going to really get out of having to be liable for any of those unknown debts in the past. But in any event, so that's what we have for a 30,000-foot level view of stock purchase transactions from a tax effect. So feel free to contact anybody at the Dickinson Law Firm, and we can give you some more in detailed information on that. Next up is Howard Hagen, who is our keynote headliner speaker. He's always informative and entertaining as well too. He's going to talk about, how the times are changing. And that's pretty much always the case, isn't it? We're going to bring Howard up here right now.
Well, I'd like to welcome you to the last session of the day. I don't know why they called me keynote. It's mostly notes. And what I want to do here today is provide my typical sort of 30,000-foot view of where we are in the world and how this impacts banking. I'm going to start out broadly and then move into more issues relating to the banking industry itself. Who would have thought that as of September 1, we would have as many COVID cases in hospitals as we had March of the prior year? I would have never thought that. I thought that perhaps maybe we were moving through this episode. At the same time, with all of that, where is the rationality? And it's hard to figure out, frankly, and I've been around a while. The stock market has basically doubled since that time. Who would have predicted that? Another sort of disruption to what we would normally think are rational economic theories relate to what one would call, you know, the issues relating to land. Yesterday, or earlier this week, I believe, land in Grundy County sold for $22,600. $22,600. That's an all-time record in Iowa. And how is that justified? And really how that's justified we'll get to down the road, at least in the viewpoint of some. So what I'm going to do here is not really help you with strategic planning. If you look at that chart, you know, that's right on. Guess, hunch, this could happen, that could happen, maybe not, and who the heck knows. But we are going to talk about where we've been and where that might lead us. The future always outwits the certitudes expressed. In other words, nobody who's standing up here should say they know for sure what's going to happen. You bankers are sort of out on a rail. These are construction people back in the 30s. There was no net. What's happened to our net? Our net is still there, but there are a lot of holes in that net potentially. And so if you think your job was risky, think of these guys on the 35th floor of a skyscraper in New York eating lunch. Not everybody would want to eat lunch in that particular point, from that particular point of view. And the key to all of this is, in order to understand your industry, you have to remember that a fish cannot see the water unless it jumps out of the bowl. What does that mean? Bankers and the professionals all are encased in the fishbowl. Sometimes we need to step back and see what is out there in the world in order to determine where we are going as a banking industry. Let's look at the past year. One of the best quotes I've ever seen was the one on the first line there, and you can read these later. I understand you have all of these vis-a-vis the internet. Not even in my wildest dreams did I imagine myself entering a bank wearing a mask and asking for money. Even that's been challenged recently here in the metro area where we had that happen, and the young lady actually did ask for money. Now the good news is she was apprehended, but the bad news is, how do you discern who is an appropriate mask wearer versus one who is not? And a couple of the other quotes are great. During the time we had COVID, many people had to distance themselves not only from people but from the fridge because they were gaining so much weight. And at the same time, you know, one needs to remember that if one person once told me if they had a second quarantine, they hoped they had a different family to live with during that quarantine. So it was a very, very bizarre world. Some people argue it has sort of rewired us. The Washington Post reports that these were the most common statements made by many. And you can see there that there's probably things you said. Sometimes for the better, we came to a reckoning of who we are. It transformed us, and it taught us really perseverance. And it also taught all of us, whether we were in families or office structures, that we take the little wins. And really the whole COVID incident is like someone looking both ways before crossing the street and then getting hit by a submarine. That was the probability. COVID doom predictions, though, really never happened to some degree. There were 5 primary prophecies of economic ruin that frankly did not come to pass. Actually, in spite of all the talk, suicides fell. And in spite of all the concern, savings and net worth rose even as consumption bounced back. Now, there's a big factor called the US government, which we'll get to here, but the point is, we did not have the Great Depression. People, for the most part, even with the rental embargo in terms of evicting people, actually, if you talk to most of the landlords, most people did try to pay their rent. And virtually all of the state budgets are much healthier than they were. And business formation increased. These are all counterintuitive to the kind of situation where you see what I would call dire straits. So out of some doom comes some good. And JP Morgan, we're going to get to what they're doing here in Iowa here in a minute. But the last line was very telling by Jamie Dimon, who is the CEO of JP Morgan Chase. He said, and it was a time when companies discovered what they really were and sometimes what they might become. And it's the they might become that I think is important for banks and bank board of directors to keep in mind. 3 things bankers learned during the pandemic. 1, customers really do want to use technology. Number 2, employees can work remotely. That surprised a lot of people. That's really going to create an entirely new workforce in terms of hybrid situations in many instances. And 3, banks did a marvelous job in a state that some people thought could never be converted this quickly to stand up digitally, and they did it well. Okay, let's look at the overall economy. Here's again, another sort of disparate piece of information. Long-term interest rates are basically are at an all-time low. Yet, the price-to-earnings ratio of the market is at an all-time high. Explain that. Some of these things are just not readily explainable other than maybe a couple of factors. One is we've got a tremendous amount of money sloshing around. This is evidenced by, if you look at the overnight repurchase agreements with the Fed in the last week, we exceeded $1.2 trillion in overnight repos. That's basically cash on hand for banks that they want to try to draw I don't know, but a little bit of interest. One other number that's remarkable is that we've in effect created money to the extent of $14 trillion in the US, China, Japan, and Europe. 14 trillion. If certain legislation passes this year, we may add another $7 trillion. There are some bankers that are worried about that, and there are others that are just kind of going along for the ride. But these are huge, huge numbers which exceed any prior experience in our society. So why don't we have rampant inflation? The best explanation I heard was as follows, and that is that the money supply. We have 1.2 trillion in overnights, repos, and the money supply is not turning. In other words, there's not any turn in the velocity of the money. It's not rolling over. What really creates inflation in the long run is the high speed of velocity creating the demands. We have no demand. That is why, in part, we're not seeing inflation take off, at least in the monetary section. And the cumulative price change has been about 6.27%, and the inflation rate has gone from 1.76 to 5.39%. So we are starting to see inflation. The question is, will this last? And part of the problem with the inflation indexes, which all bankers know better than many people, and that is that it tends to be isolated in certain sections that are really hit, that really, to some degree, aren't measured by the current indexes. And those are hospital services, college tuition, and frankly, daycare is part of that. Those are the ones that are really through the roof over the last 20 years in terms of inflationary costs that I don't believe the CPI really picks up well. At the same time, you shouldn't be ashamed to be in America. We generate $66,000 per capita in GDP. We are all worried about China. China generates $11.7 thousand. And China right now is going to be, in the next year, you're going to see they're cracking down on capitalism as you cannot believe. And I think that disparity will actually increase, not decrease. Well, does one think we're going to have long-term inflation ahead? I'm actually, contrary to a lot of people, think that in the long run, in the short run, yes. In the long run, digitization, globalization, and concentration are really impacting wages. I have a son out east, and he's involved in some heavy-duty hiring. They can get people for $10 an hour in Canada that have normally command an $80,000 salary in America. Where do you think those companies are going? The other thing is we have shrink inflation. What is that? That means that that the prices, for example, at the grocery store may not be going up as much as you think, but look at the packages. The packages and all of that is starting to shrink. It's really an interesting phenomenon. And the other thing that may be impacting this is really to help inflation, we need, frankly, which is counterintuitive to some other environmental issues, but you need growth in population. The United States is flat, China is very flat, and the countries with the economic power do not have that kind of surge of demand. And so that, in my opinion, may keep long-term aggregate inflation in check. At the same time, while we concern ourselves with inflation, there's been dramatic movement, as reflected in the banking industry, among employees, key employees. You're seeing transactions really throughout Iowa where officers, particularly loan officers, are moving from one location to another. They may or may not have a non-solicitation agreement or a non-compete, but they are moving. And why is that? Because of the lack of demand for loans in their current markets. So how do you expand that? You find an officer with a relationship and just hope and pray that there's no litigation. And there is some litigation now in Iowa, so it is not without a cost or a risk. In fact, some industries with these high, rapid, dramatic movements are actually following the pro sports attitude, and that is when you sign the contract, if you go somewhere else, you have to pay the company X dollars. What does that really mean? That means the party that's hiring you has to pay your company X $1,000. This is true in the more service industries, but I think you could see this occur in the professional industries. In other words, truck drivers, if they leave a trucking company, they have to pay the other trucking company X $1,000 for the right to basically hire that people because the person has signed a contract with the initial one. So there's all kinds of creativity that's going to go on here. A real sign of the times is as follows. I was at a hotel and they were short of people, like all hotels are. There's a dramatic dearth of employees for hotels and leisure, and we'll get into that in a minute. So I asked the person behind the counter, have you been employed here a long time? And she said, yes. And she said, yes, I've worked here for a week. I've worked here for a week. That's the sign of the stability of the employees, particularly younger folk who find themselves being able to move around. And the employment changes that you're going to see most dramatically by industry sector are leisure and hospitality. There is an absolute problem with hotels and restaurants being able to stay open or have extended services for any period of time because you can't hire the people. And other people really don't even want to go to physical locations. They want to work out of their home. But there are some real struggles with that. And I think that's true in any industry, frankly, whether it be marketing or law or all of those. Collaboration is kind of essential for communication. And a lot of people just frankly are bored at being at home. So I think that will change, but I think it'll be a hybrid model. And again, here's evidence of the growth in leisure and hospitality in terms of month-over-month attempts to hire. Where have the wages gone up the most? Ironically, leisure and hospitality. I read, and we'll get into that in a minute, about a bank coming to the Des Moines area who's coming, frankly, out of New York and what their starting salaries will be. And that's an exception to this rule. But the primary increases are in leisure and hospitality. So, why are all these hospitality workers switching? Different work settings, higher pay, better benefits. It's the work settings in part. And the other curious thing that the Journal had this morning, if you haven't caught it, you might go read it. And that is for all of the states that have reduced unemployment benefits, actually their increase in payroll has not been any greater than those states that have maintained them. In fact, the Journal reports that the states that have maintained them have had higher payroll growth. That's a head scratcher. It means that maybe values aren't what we once thought they were. So you need to rethink your working environment, even in the banking industry, as we move along with these younger generations. Jobs. This you can study this later. I don't want. This is just to indicate to you that basically we're moving out from one set of technology to another set of technology, and AI is going to be very crucial to that. What does it mean? in this environment? Well, it's a disrupted environment, and disruptors are usually entrepreneurs, outsiders, idealists, and rather those in the industry. They come in with a fresh look, and they maybe take old ideas and make them expedited through the world of the internet. The results are that the current business model, regardless of the industry, is going to be challenged by that. And that challenge will be delineated as we move along here. This is Iowa today. Who would have thought Amazon is hiring, what, 44,000 more people in the United States alone in the next 6 months? It's going to be interesting to see what the pay is for that. And living in suburban Des Moines, on our street, which is a block long, that Amazon truck, if you just sit there and watch, even on a weekend, stops at 5 houses in one fell swoop. They are a dominant player. And what we don't realize is the size of some of these entities, whether it be Apple, Amazon, Microsoft, those three have market capitalizations in excess of $2 trillion. Who would have thought that? That is very, very strong economic power. And wherever they want to go, like a big whale or big shark, you have to follow. The curious thing in this world is how it's changed in terms of those valuations I've just talked about. If you look at this next chart with all of the companies who produce all of these cars, in terms of the number of cars sold, is 121 to 1 Tesla. Yet the market capitalization of Tesla is as great as Toyota, Volkswagen, General Motors, Honda, SIC, Kia, Ford, Chrysler, and Renault combined. Think about that. That's a sign that the virtual side of this world is dominating the economic environment as we know it. That is just incredible to me. Now, can that last? I have my doubts, but right now, the market capitalization of Tesla exceeds all of those. And it's on the expectation of their growth. It's not, this is an interesting thing for bankers. It's not on what they've done, it's what they can do going forward. And it's all really perspective, not retroactive. This would drive many of the accountants I know crazy, but it's the reality. Here's the other very telling point about how the economy is changing. From an economy where you can touch the tangible things that are produced and assets to the intangible assets. In 1975, only 17% of the assets owned by the, I guess it's 500 largest companies in the country were intangible or virtual. Today, 90% of their market capitalizations relate to intangible assets, things you can't touch, not physicality. The only real odd exception to this and something to think about is agriculture. It still is very tangible, but all of these other industries have shifted. And this is reflected in a little episode we just had. I woke up sweating. Some Texans were shocked to find out that their thermostats were remotely controlled. They have no control over their physicality. Why? Because the utilities down there graciously all installed their thermostats for them, but when they installed those, they signed an agreement that said that the utility company could control their thermostat settings. Who would have thought of that 5 years ago, let alone 5 months ago? But it happened down there in Texas when they ran into the problems. And part of this is also in the virtual side impacting how we communicate. Social media may be tearing up the country, I don't know. But it's clearly an element that a majority of Americans look at things differently based upon their social media feeds. And this is particularly true for younger people. Respondents who changed their opinion through social media content. The highest percentage was the 18 to 29-year-olds. And that is fascinating to me that they were most influenced by social media. Let's look at agriculture just a minute before we get to banking because it's so important to Iowa. And it's being changed disruptively. It's reported that the income for an Iowa farmer from the federal government was about $150 per acre in terms of basically contributions to that farmer. There's no wonder there's no loan demand. There's no wonder there's very little stress. But everything reverts towards the norm. If you learned anything in economics, that's number one rule. And here are the prices, and we're at an all-time high. So what is it? How does this translate to land? We've got prices at on a relatively steady basis at a real high level. We've got basically free money, and we basically got farmers with a lot of cash. That's how you get the prices we have. It's not on the ROA on the land itself. You can't tell me that the people are paying $500. They may be, but most aren't yet, in order to justify some of this. So what's happening in ag in terms of disruption? Everything's turning into technology. I don't know if many of you noticed this morning on CNBC, they featured the Farm Progress Show in Illinois. And it was typical kind of East Coast. Have you ever seen a machine like this? I'd like to drive this down a New Jersey street. It was $1 million combine, $1 million combine. And they were just fascinated by it. But the more important, that $1 million, a lot of that is in the software. And so as a result, those combines aren't the physicality, it's the software. And that software is important to a lot of other people. And if you think of the parallels to ag and banking, technology is becoming very important for bankers as well. There's immense computer processing capacity of banking, or of agriculture, and they're collecting this data. The major seed companies are collecting this data. They're getting, your combine is collecting this data, and it's making decisions based on that, both for the seed company and the producer. And there are many, the other thing that's shifted is, guess what? Follow the money. 1.2 trillion overnight. They're now looking at ag pretty heavily. Some of the biggest quiet investors in ag at the moment are Google, Amazon, BlackRock, IBM, and Microsoft. And I bet you've never heard of them. So they all recognize that food remains a critical part of our element, and quality food and safe food and food that doesn't harm the environment are all elements where they think they can make a buck. Here are some of the future ag disruptions. I won't belabor them, but the ones to follow as bankers in the next year are really the carbon credits and the rise of electric cars as it impacts. Those others are going to be there, but those are two where once we get a way to measure carbon credits, Katie barred the door in terms of valuing farmland at a little bit more perhaps, because and not necessarily all good farmland. That's something people have to realize. Some of the bad farmland is actually better from a carbon credit point of view than the good farmland. And another area, third area, is meat. And it's not the plant-based meat, which has all kinds of side effects in terms of how you make the plant food. It ends up, if you believe meat is toxic, which I don't, but if you believe that, the plant-based food has the same problems. But what is going to occur here in the next 10 to 15 years, and that is the so-called meatless meat or organic meat, where they take a cell and basically grow the meat right in front of you on a volume. There are 3 articles there. Go to, and I'm very supportive of Iowa State, but University of Illinois Ag Group is probably the most focused on this, and it may be for political reasons, I don't know, but take a look at one of those. It's not going to happen overnight, but basically that will lower the cost of protein greatly. And it's not so much the health benefit, it's the cost benefit. And this is why you see little companies like ADM and Cargill in meatless meat playing around trying to create a chicken meat out of cells. The cost of proteins will be 5 times cheaper in 2030 and 10 times cheaper in 2035 based upon this development alone. That will have an impact on farming. The other impact is 53% of the Iowa corn goes to an ethanol plant. 53%. What happens? At least 2/3 of the global car sales will be electric by 2040. If that happens, what happens to corn production and the pricing of this high-priced corn? Some would say fair priced. And it's clear the corn growers have recognized this. They are trying to figure out how to gain these carbon credits. If you go to that second, you can get this online. Biofuel industry seeks inclusion of ethanol in the carbon reduction plans. That's not an accident. They're trying to offset what they see as a decline in the electrical industry. And the Ag Department under the Trump administration and now under Vilsack's going to carry this out. He wants to cut the climate footprint. How do you do that? You eliminate methane and carbon. And as a result, you're going to see carbon being measured within the next year. And once that happens, then you can start to pay a price for it. The key coefficient in these disruptions in ag and frankly in banking is consumerism. The consumer now controls the product. They're demanding quality, purity, and knowledge of sourcing. This has led to enormous, why are they doing that? Because they just feel it's better, and it's led to a phenomenon called ESG, which you're going to hear a lot of. The major corporations are going to be scored on ESG. What is ESG? Environmental values, social values, and governance. Blackstone and State Street, who indirectly controlled $10 trillion worth of investments in America, 10 trillion, those two companies have said we're expecting ESG compliance and we're going to start scoring who we invest in based on that, which is a totally different fixture. It's again, an intangible element that is invading our tangible measurements. This is going to drive the accounting firms nuts. And if you just notice in the last month, some of the accounting firms have said, we got to figure out how to measure this. This all sounds a little weird, I'm sure, to a lot of you out there, but it is there. But don't undersell Iowa. We're producing a lot of data. The data will be valuable. Blockchain will help sourcing. In other words, you trace it from the kernel to the consumption. And Iowa, even though we've all heard it made fun of, actually has the highest reputation in agriculture in the world. I mean, there's a reason the Japanese used to come here 20 years ago to farms, which I'm familiar with, come to farms and go out and smell the soybeans. And they would pick the soybean fields based upon their viewing and the smell of the field. And they would pick specific fields and they'd offer humongous amounts of money for you to grow soybeans there. Why? Because tofu is a key element of their diet. So Iowa has a distinct advantage, and don't let anybody sell you short on that. And I think we'll do just fine in this. Banking trends, you all as bankers are very familiar with this. You should read it every quarter. There's always a lot of news in banking, and I'll leave it at that. But here we get the rubber hits the road on practicalities of this presentation. There was an attempt by the superintendent of banking and his staff to work diligently to modernize 524, and they did so, and there was input from the associations and various interested parties. Anybody who wanted to attend those meetings could, and they came up with legislation. It got to the Iowa legislature, and I believe the Senate passed it almost unanimously. It got to the House, and it was stopped because there was some concern about the ability that it might impact credit unions. I'll leave it at that. That's just the fact. But next year, this upcoming year, if you've got any ideas, I would forward them either to us or to the division or somebody about how to improve 524. Maybe we've still got a chance. But it streamlines meetings. It streamlines the regulatory process. One great opportunity for banks is that it expedites trust transfers. In other words, if you as a small bank want to get out of the trust business or somehow work with another bank to provide trust services whereby you retain the customer, this can be done much more easily than it used to be. Another real sleeper in it, which reflects what's probably coming here, and that is it authorizes banks to invest up to 5% of their capital in a subsidiary to engage in fintech activity. Now, why would an Iowa bank want to engage in a fintech activity? Because the fintechs are approaching Iowa banks about working with them. Why is this important? Because ironically, one of the things we talked about earlier today, vis-a-vis data processing, the big data processing companies are very concerned about these fintechs kind of nibbling away at them and providing direct services to banks that they try to provide on a comprehensive basis. But the point is, we've already seen a subsidiary or two created that would in effect allow a bank to engage in insurance activity, and the algorithms in a subsidiary that is jointly owned with a number of parties would then determine who in their client base would want one kind of insurance product. Gives you a huge edge. It catches you up with Amazon. Amazon's been doing this with you for 10 years. These fintechs want to do it for the banks and identify what the customer needs, because remember, your customer is in control. And if you can figure out, just like Amazon figured out, you might be interested in this, lo and behold, you might get some sales. And then we've got the Green State legacy. Green State keeps growing. They will probably blow by $10 billion pretty readily. And curiously enough, they've been, they've applied to purchase a bank in suburban Omaha and suburban Chicago, both of which have the same demographics as Jordan Creek, and I'll leave it at that. Time's up. From the banking's point of view, Congress must stop credit union purchases. And the real theory is they should be regulated equally. If the big credit unions want to do what they do, they should be regulated like banks, number one. And two, they should be paying some taxes back to the state, because theoretically, if this keeps going, you could end up with a non-taxed set of financial institutions, which is to the detriment of the state of Iowa and perhaps local communities. Also, another hot trend in banking is ransomware attacks are becoming more common. That's true of your customer base, and I can't stress enough how you should warn your customers. Get insurance. Get insurance. It may be diminishing now because of all the claims, but you're much better off getting insurance, because not only do the insurance companies provide you some economic benefit, but they also have the expertise. We work with an insurance company who hired the negotiating crew, which came out of London, which had 10 years experience in this. They also then negotiated the deal, because this was not a bank entity, but a private entity, negotiated the deal and cut the price down. Both they and the FBI told us, pay it. They're good for their word. They came up with the money, but it had to be paid in, guess what? Bitcoins. The insurance company had a firm in Toronto, Canada, that did the swap from cash to fintechs. That's all they do for a living. They have a good business right now, and did the deal. And then 10 days later, the impacted, this happened to be an engineering company, got a nice note from the, I call them Pirates of the Caribbean, thanking them for the money, turned the system on, and also gave them 10 tips as to how to avoid this in the future. It is quite a world out there. And look, if you look at this chart, you go where the money is. And guess where the money is, according to this chart from The Economist? It's, guess where? In the financial institutions. So they'll keep pecking away. Even the ransomware is maybe hitting agriculture. There have been some flaws discovered recently in the John Deere systems. John Deere is laden with software. Now they argue, well, we've got that under control. But anytime you add more technology, you have to assume you're opening it up to the world. And that's what's happened. FinTech has come to America. There's a phenomenon that you're going to hear a lot about called neobanks. And they're not quite banks, but they may have FDIC insurance. And a classic example of that is Square. Square has just received approval to become a bank. They're going to be an insured bank. And they're launching major suite of savings, checking, and loan services in a major banking push. What are they doing here? What's happened here? Remember 30 years ago, we used to have installment loans when you bought an appliance, and that all disappeared because of the paperwork hassle, and we kind of switched to credit cards to pay for all that. They've realized that they're in the payment source, the cell phone. And keep in mind, there are more cell phones now than human beings in the world. More cell phones now than human beings in the world. That puts it in perspective. You put the Square in the cell phone, they notice the transaction, they say, oh, by the way, we can loan you this money directly. And lo and behold, it's the old installment loan brought virtual. And then they've just announced that they finished this off by buying a huge company in Australia that basically is a buy now, pay later. That's the installment loan personified. You go out and buy that washing machine, and we'll finance it. And we've got your cell phone, we've got all your other information, where you bank and all that, so it's coming. A key element to keep in mind in the next 5 to 10 years for some of you is that this virtual trend that I talk about that's apparent in the world, they did some surveys about what they call invisible payments. No cash, no checks, no debit or credit cards or wearables. In other words, they just know that when you pass through that door, you're going to be debited for whatever you have in your hands. And if you look at the trends of extremely interested, it's not on the boomers, it's not on the Gen X's, it's the millennials and Gen Zs who are eager for checkout-free technology. In other words, don't hold me down. Don't fence me in. So FinTech's future in Iowa is basically, there have been a transaction or two where maybe some FinTech owners, not FinTech companies, have started to look into and acquired banks. They also are interested in working with subsidiary of Iowa banks. And what you may see are fintech subsidiaries that aren't owned by just one bank, but owned by 10 banks who get together on an idea. And those partnerships will increase. Now, all the regulators are very cautious, and their antennas really go up when you talk about cyber currency or anything like that. I had a meeting here in the last month where we talked to one of the regulators just about the concept. 13 people from the regulatory authority signed up just to hear us talk about it. What does that tell you? They're very cautious. Now, what they've told me is that by sometime in October, the Federal Reserve, the FDIC, and the OCC will come out with some basic paradigm or ground rules for how you deal with fintech and cyber currency, et cetera. And Bitcoin, for those of you who are novices, which I can't believe there's anybody left, go to Wikipedia. It's a tremendous summary of how it works. And then also don't forget to follow, President Trump set this trend, and it's carrying on with President Biden. In one of the longer executive orders here, he talks about promoting open banking, and I'll describe that in a minute, and data sharing. In other words, this total interchangeability of information without having to go through the bank, which, believe me, bankers, cuts both ways. And he also talked about increasing merger oversight. He's not talking about Iowa banks, he's talking about other banks that are very, very large. And ironically, buried in there, and I think Vilsack had a lot to do with this, 30% of one of the orders was ag content about what we need to do in ag vis-a-vis carbon and safe soils and all of that. So carbon credits, in there was a distinct discussion about carbon credits. This is a chart you need to look at a little later, and it's basically the difference between closed banking and open banking. Customer deals with a bank, and then the customer moves from out of one bank to another. In this chart, you see that the customer has these interrelating, really fintech companies that can move accounts and money around. And they're sort of doing that anyway. Keep in mind, if Square is on the front of the deal, makes the loan, knows where your bank account is on the cell phone, they've got all the information they need to do even the ACHs under the old-fashioned way. With open banking systems on the horizon, the fintech and SME, means small and medium enterprises, love this because it saves them what I call friction. And we'll talk about that in a minute. And here's a very academic, you don't have to go to it, but they basically argue that if open bank finance continues to accelerate, it could reshape financial services ecosystem, change the very idea of banking, and increase the pressure on the incumbents. This one chart is, I think, the winner of the whole presentation. It is a chart that shows how apps have taken the old world and offer you three alternatives. If you look at taxis, it's Uber, Lyft, and one other one, shopping malls, takeout, meet through friends, real estate agents. These are all apps that take out what I call the friction. That is human beings in the middle of the transaction, the intermediaries. This one chart, and the list is below so you can figure out who these people are. It just flows down the chart. That is the most telling thing about where we're going in the next 10 years. It's app driven. So why in the world would I keep a branch? Why have physicality anymore? Well, I'm going to tell you, I think physicality is more important than you think. There are polar opposite views about branching versus branchless banking. And this tends to go in wave or cycles. In other words, for 5 years, it's don't build a branch. For the next 5 years, oh, you need branches. JP Morgan has just opened their first branch in Des Moines, Iowa. They're going to open, I think, 4 others. And what I think the major banks have discovered, and there's some data to support this, and it's really good for you too, and that is, why might a big bank come to Des Moines, other than maybe wanting to be in every state? That could be a reason. But another reason could be perhaps that if I have physicality here, if the customer can see my branch, the online stickiness goes up, and there's all kinds of data to prove that. And that's part of the reason Amazon is now talking about Amazon stores. They've all figured out that if I have physicality in that market, my online marketing increases, it's roughly 30 to 40% in terms of stickiness. People will come to an online that they can physically see, even though I bet these large banks really don't care how many people go in those facilities. What they care about is that if you start looking at their locations, they're on major thoroughfares and all of that. They're designed to be seen and to create a sense of stability. Now, they've figured out that's always been the strength of the community banker. The community banker is somebody who can go choke their throat if something goes wrong, even if they have outsourced it. They know they can go there. So that's primarily the benefit. In terms of bank transactions, really there's not any apparent capital issues out there. What's really driving transactions to either sell or buy are talent and time. People are running out of time and they've decided, well, I'm an S Corp, I'm going to take my money and run and do what I want to or spend it where I want to. But it's also about talent. It's frankly getting more challenging, and banks have got to figure this out, how we maybe even remote some of our help in community banks because they can't get the talent. And I'm telling you, premiums tend to go up a little more if you've got talent along with the bank. And right now, that makes deals more attractive if you've got talent. Because what do we have in this world? A year and a half ago, you could market almost any bank in Iowa, and the theory was it will enhance your liquidity because people were searching all over right and left for deposits. That's no longer true. We're awash in deposits. And so I think that deals probably will increase dramatically in 2022, and I suppose many of you want some price differential. It is literally all over the park. I've never seen the spread so great, either high or low. And if you want to corner me, just give me a call. But it's unfair to try to quote a particular price. But those other elements play into this. These are some predictions. I'm not going to belabor those, but there's something you can study of 2021, and a lot of them are in fact true. So the really big issues as we move forward are that will impact us it's the autocratic democratic is really the China-US fight. Can China run a quasi-capitalist system where they sort of try to create equality, limit access to information, and really flourish as an entrepreneurial society versus a democratic society that's very chaotic, frankly, not always runs as smooth as the top, but it does create a lot of opportunities. Technology versus human. That's another battle that's occurring. You're going to see it in the banking industry, and you're going to see it in every other industry. How important are humans? I think they're important. But at the same time, a lot of these fintechs, for example, that we know, are focused on insurance because they think they can automate basically the back rooms in these big buildings in downtown Des Moines here. We're going to find out. Isolation versus integration. Can we really isolate ourselves, or do we have to be a part of it? And fear versus hope. And you always got to, fear does you no good. Hope does you a lot of good. As individuals, here are 6 ways to reset. You could look at those. That was actually for another presentation, but I threw it in. You know, you basically got to interface with the community, develop your own identity. Some words to remember. Virtual velocity. What I've talked about here throughout is how we've gone virtual and that things are speeding up. The so-called Square idea is really speeding up the old installment loan idea. Friction points versus frictionless. The people who are really going to make a lot of money in the future are eliminating friction points. Classic example, Amazon. Amazon is a classic example. They eliminated a lot of friction points. I don't have to go and look at 6 stores. I don't have to drive. It doesn't take time. It's all on a screen. And by the way, I don't even have to go get it. That's a frictionless idea that Mr. Bezos had. And to the extent that you can develop bank products that are focused on the customer that make it real easy for them, i.e. frictionless, you're going to be better off. Agility. We just need to be very, very agile in a world that's topsy-turvy. And another point is AI is not absolute, because the old expression, which maybe many of you heard 100 years ago, garbage in, garbage out. One of the problems with relying on AI is it doesn't have any doubt. You feed the information in and it comes out with an answer. No doubt at all. So and finally, the human touch and engagement are key. That's the real strength of Iowa banking, is the human touch. So we go from there. Who's in charge? It's no longer you, banker. It's your customer. It's not about them meeting you, it's you meeting them. And everything I've talked about is where you try to create engagements where you're providing something that they want without them having to do much. Suggestions for surviving as a banker in a rapidly changing and disruptive environment. Be selective. You know, this doesn't mean rush out and talk to every fintech in the world. It means be selective, but don't close the door on a lot of them. Some of them are really worth listening to. A lot of them will not work. A lot of them fail. My oldest, that's what he does, is pick out VCs for various people to invest in, but you've got to be careful. Do not just plug and play. Know the outcomes and references. Henry Ford said, it's not the answers, you got to ask the right questions. So as an industry, we need to ask the right questions. And there is a bit of safety in numbers, so if some people are doing it, you might kind of look at it. But you'd have to always be listening and learning, trust but verify, and how do you differentiate yourself from that vast mass of people? Does it complement your organization? And just, you know, you've got the liquidity, maintain and, you know, raise the labor, and always be thinking about succession, because none of us ever know what might happen tomorrow, and be open to change. Mr. Breck said it right, because things are the way they are, things will not remain the way they are. This has been accelerated by the virtuality of the world. So I'd like to thank you and hope, I don't even know what time it is. Do I have time left? How much? Okay, well, you're at the end of the day. You know, here's where I'd love the Q&As, but we don't have that very readily. So with that, I want to thank everybody who has participated in this presentation today. A lot of them were hard, you know, you may want to go back and check YouTube out and listen to one at a time, because I think that's important, because some of these, to have us thrust even on a 20-minute cycle, the idea here is to give you a lot of menu to select from. So I want to thank everybody, including Sarah and the staff here, for providing a vehicle. This is an experiment for us. We probably will do more of these, but at the same time, I'm an old-fashioned guy and I like in-person meetings. So with that, I'd like to thank you, and always remember a motto we adopted 10 years ago, which turns out to be really appropriate, and that is, be calm, bank on, and navigate through this world that we live in, and enjoy it. Enjoy the wonder of it all. With that, I'd like to say thank you and have a good day. Bye.